My lord, may we permitted to mention one contempt matter? My lord, these matters were decided by the division bench of your lordship and Honorable Justice Shupradin Bhattacharya.
Give it. May I permit to mention one was the restoration application and one was the inclusion for a contempt application.
Contempt of order passed by this bench.
Yes, lordship.
Contempt list in the next week. Restoration also both list in the next week.
This is mentioning regarding that Tivoli court matter. When Mr. Mukherjee was contested and Mr. AG was represented.
Terrace flat.
Yes, my lord.
Yes.
My lord, it was 19 fixed. My lord, AG has the fixed matter of the state at 2 p.m. My lord, so I have given 48 hours notice to the other side. I kindly fix 24th, 25th, 21st, any date instead of 19th, my lord. That's my innocuous prayer.
In their absence, how it
My lord, they are intentionally not appearing. That's why I have given 48 of Friday. I have served the notice to the other side.
whatever it is.
Mentioning the dates for modification.
So they are on notice on 19th. When it is taken up, we'll accommodate you. Not like this, not behind this. We'll not do it.
Well, then, 19th is kindly accommodate, my lord.
See, we cannot promise you anything, but you have done what is required to be done. We'll see on 19th. Let them be here. Yes.
The matter for inclusion, madam.
Give the inclusions you may give.
Sir, I let you not put the
No.
Item number 3.
Not available on.
My lord, I was appointed as an agricultural development officer. Then, my lord, a complaint was lodged by some dealers of the district, by the dealers, my lord, who are dealing with the MF dealership. Now, on the basis of the complaint, my lord, an inquiry was made. Then, my lord, a show cause notice was issued alleging that the allegations have been raised against me. Then, my lord, as a logical conclusion, my lord, a charge sheet was issued. I was asked to give a reply to the charge sheet. Now, the alleged allegations, after reading the charge sheet, in my opinion, my lord, it comes as disproportionate assets. Now, then and also there was a further alleged allegation that I did not submit the required declarations which are required to be submitted by the government officer. Now, my lord, reply to the charge sheet was submitted.
Meaning thereby declaration of assets.
Declaration of assets. Now, my lord, I had submitted a reply to the charge sheet on 3rd of February 2012.
2020.
No, 3rd of February 2012. And the charge sheet was issued on, my lord, before that. Then, my lord, it appears, my lord, that an inquiry report was submitted. This was submitted on 9/11/2020. Then second show cause. Now, my lord, find, my lord, that there was a penalty of reduction of pay to 5 stages. When this was going on, my lord, it appears, my lord, that at page 131 to 132, your lordship will be pleased to find that a penalty was imposed of reduction of pay to 5 stages with some other cumulative effect. Now, my lord, I have challenged the validity of the departmental proceeding. Matter was filed before the State Administrative Tribunal. Now, my lord, in the usual form, my lord knows, my lord, that the orders, my lord, which are passed that this matter is required to be heard by a division bench. This was going on. Then, my lord, a subsequent order was passed on 6th of May 2025 for placing the matter before two benches of two judges, my lord, comprising of the judicial and the administrative. Since there is no bench, my lord, this cannot be done.
Did you avail the remedy of appeal?
The departmental appeal,
Yes.
my lord, truly speaking, I find, my lord, that that was not availed of. That I also told my learned junior. That
How it is maintainable before the tribunal?
that's right. Now, my lord, I would be, I would submit, my lord, in my opinion, my lord, the remedy of appeal is required to be availed of. This is number one. Although my lords have laid down the law in many cases that existence of an alternative remedy does not house the jurisdiction of the court, but even then, since these are the
The rule of discretion, there is no
That's right.
power. But
That's
that is for 226.
that's
You are approaching the tribunal under the act. Statute mandates availing of alternative remedy.
Milan, may I submit one thing? And there is another thing which I should submit after perusing the brief, because this I submit to my lords, my lord, as an officer of the court, that my lords have also delivered a judgment that if you have, relying upon the judgment of Roger Matthew, that if you have to approach the High Court, the first remedy which a person should avail of is before the single bench, so that he is not being excluded of his remedy of availing of the two forums.
Forum is not lost. A forum is not lost.
That's right.
But that we have delivered in WPST 209,
Yes.
where we have said that, for example, in your case, he had invoked the tribunal jurisdiction long before it became non-functional.
Yes.
So therefore, that will come before the division bench. In matters where they have not approached the tribunal and tribunal has become unfunctional, non-functional, then they should come to the single judge.
Yes.
Because as of today, the orders passed by the tribunal will have to be set aside or interfered to give any relief, which cannot be done by a learned single judge bench because of the judgment of L. Chandra Kumar.
Yes.
So therefore, that issue perhaps may not arise in the present case. The issue remains whether
I have availed of the
it
alternative
was
remedy.
maintainable before the tribunal or not. Only if it was maintainable, then we can assume the
The
jurisdiction.
learned tribunal did not, my lord, in my very respectful submission, my lord, kindly see the orders. The learned tribunal, my lord, did not examine the matter.
Any because section 20 and 21 are clear.
My lord,
Section 20 and 21 of the Administrative Tribunals Act is clear. Okay. TC 20 and 21.
yes, 20, my lord, it provides, my lord, that
Starts, it's in negative terms, not to be admitted unless
admitted unless remedies are exhausted.
exhausted. So there is no, this is not a rule of discretion.
Right.
When you approach the tribunal, there is a statutory bar for availing the statutory remedy.
May I submit one thing, my lord, because I think I should not further argue in the matter. I should only, my lord, appeal to my lords to permit me to avail of the remedies.
Let him. So we'll hope that no issue of delay will come in his way.
Yes.
Yes. Full stop. Heard the learned
One thing, may I submit one thing? That if I file an appeal, if the authority may not again, then I have to come. Kindly direct me that if the appeal is filed, the authorities will dispose of the appeal.
Be without, may not be deemed to be an
Which the appellant receives a copy.
Okay, then we'll make it within 60 days. You do it within 60 days.
Date of change which is. This has been possibly changed.
Item number 4, I appear for the applicant. My lord, most probably your lordship, I think this matter, my lord, has to be, my lord, it is an order coming from the order of the Honorable State Administrative Tribunal for the lack of, my lord,
Was filed after August.
yes, my lord, yes. Filed
Then
after-
you will have to go before the
My
single.
lord, for some medical treatment, your lordship. If it could be transferred, subject to your lordship's, my lord,
Cannot be. The entire framing of
my lord,
the
the
petition.
form remains the same, your lordship.
No, it doesn't.
If it could be, my lord.
The order of the tribunal will not be under challenge before the honorable single judge. It will be a totally different, it will be like a OA.
Understood, my lord. Yes,
So
very
same order will pass.
Very well.
And we are also allowing you liberty. Otherwise, you cannot file it before a division.
Deeply obliged, your lord.
Item number 5.
My lord,
Yes, 75 AAA.
my lord, there are two sets of statutes in respect of voluntary retirement. One is West Bengal Service Rule Part 1, and that Supreme Court judgment and High Court, different High Court judgment specifically apply in the case of voluntary retirement covered by the West Bengal Service Rule. In my case, my lord, applicant filed the death cum retirement benefit that is included in the voluntary retirement VR scheme.
Which provision? We asked you on the last day also. Which is the provision in the
VR scheme is here, my lord,
Yes.
page 64,
Page
page 62, 63.
of the brief.
VR scheme, sir.
For an updated one.
দেখছো তো page 60 বিহার scheme as per the scheme by lot it has become a amended rule under rule 61 of the DCRB rules. 60. It is at present it is a amended rules. My lord. আপনি আছেন আপনি আছেন এটা my lord.
Paragraph 13, 14.
My lord, have a look at the para 13 and 14 of the scheme, my lord, at page 64.
Yes.
May I read, my lord? The benefit of voluntary retirement under this scheme will not be admissible to the holder of certain services and posts as enumerated in Rule 59 of the West Bengal Service Death Cum Retirement Rules 1971. Now, my lord, Rule 51, West Bengal Health Service is there, but West Bengal Medical Education Service is not there.
We don't understand what you are trying to submit.
Explain করুন না।
How West Bengal Medical Education Service is relevant to Rule 13 or 14?
Service rule 13 কি করে হচ্ছে?
You don't understand how you are trying.
I preferred the application under scheme, my lord, and relevant
And the scheme is under the DCRB.
DCRB, my lord.
Very well.
DCRB, my lord.
Very good.
Have a look at the page 67, my lord. Not 67, 65, my lord. Application.
Yes.
Where is a specifically mentioned, my lord.
Yes.
As per the scheme.
No, you can mention anything. You can mention anything. It is open to you to write anything you like. You have to show that there is a provision of the DCRB. Just because you say DCRB, it will become application of the DCRB.
DCRB, my lord,
And you can say it is an application under anything CPC, then it will become under CPC.
my lord, I confine myself, my lord, my argument exclusively within the scheme, my lord.
Which scheme?
That is here scheme, my lord.
Which scheme? Which scheme?
Page 65, my lord.
Yes, where does it say that application is to be made under DCRB? Please read.
I have
Anywhere. Please read from that scheme to show that it contemplates making of an application for VRS under any DCRB provision.
my lord, this para 13 itself discloses that
All right, so part 13.
it is a part of the DCRB, my lord.
Very well. That's all.
It is part of the DCRB.
That's all.
DCRB, my lord, further stated
Yes.
that is Rule 59. The officers or services, different or 19 services are included here.
Yes.
Here, medical education service is not there, my lord.
Yes.
59, my lord, I have a book is
Yes.
there, my lord.
In 59, does it say voluntary retirement? Rule 59, where does it use the expression voluntary retirement?
Here it is this scheme.
Sir,
Benefit of voluntary retirement under this scheme will not be admissible to the holder of certain service and port as enumerated in Rule 59. That exactly I mentioning, my lord. This Rule 59 is
does not have medical education. Sir.
yes, West Bengal Health Services there,
Yes.
but West Bengal Medical Education Service is not there.
Very well. What is the date of this scheme that you are reading?
That is scheme was
81. And
81.
what is the date of amendment to 75 AAA?
But it is all.
What is the date of amendment to 75 AAA?
Amendment is a new book. Here is
What is the date of amendment to 75 AAA? You please tell us.
here is mentioned, my lord, this scheme. Notification ta 75 is a service rule, my lord.
75 AAA is an amendment of which date?
75.
My lord, what I read, my lord. The state government employees are other than those mentioned in the Rule 59. Scheme of voluntary retirement has
We
been.
are not asking you to read the same provision again. That will not be of any fruitful purpose. You can read it 10 times. We are asking you what is the date of amendment to 75 AAA.
Oh,
It is before 81, it is after 81.
This is the 75 notification.
What is it after 81 or before 81?
After 81, my lord.
Very well. That is what you wanted to assert.
That is after
Much after 81.
81.
Much after 81.
But this is a two sets of books, my lord. Either a state government employee, either this service rule or DCRB.
That's
so
what-
I availed made the application DCRB, my lord.
Yes. There can
My
be
lord.
any provision in the DCRB for making an application for VRS.
And এটা চাইছে না
VRS তো
the date চাইছে শুধু এই Sir, my lord, the account আরে এটা সার্ভিস রুল এটা
DCRB টার্নিং
No, we have the DCRB.
nahi hai.
It's right here.
here, my lord, also and the West Bengal Service Rule Part 1 will be taken separately by department in due course. So there is a mention in respect of service rule, there will be another amendment which has no connection with the DCRB rule. And I have the judgment, my lord, three judges benches. Only this point, my lord, I mentioned, my lord. No. This is one, my lord. Three judges bench, my lord. That is, in the case where there is a VR scheme, my lord, specific period of 3 months notice. After expiry of notice, if there is a no communication, either acceptance or rejection, so automatically it shall be deemed to have been retired and the pension payable. This is the judgment, my lord.
For that, you don't need to show us a judgment. For that, you don't need to show us judgment. That is all right, but that is provided you are eligible to invoke the concept of voluntary retirement. If you are not eligible, what is the question of lapse and automatic
My
acceptance?
lord, I have
That comes later.
Rule 59, my lord, I am
That
eligible.
we have already said. That we have already said. You have said sufficient number of times. We are waiting. If you have to submit anything else, then you may submit.
Then I am coming next point, my lord.
Yes, come to the next point.
Next point, my lord. Next point, my lord. There is a specific period I have mentioned, the 3 months. After this period, it was expired on 3 months after 24th August, 24th February, March, April, May. 3 months expired, but no communication was received by my client, my lord. And it was issued in the month of, my lord, March 2021. Supreme Court and 3 judges bench, 2 judges bench, even different High Court, my lord, held that if the communication is not reached to the applicant within the mandatory period, it shall be deemed to have been retired or deemed to have been acceptance. This is the case, my lord. In addition, my lord. Now, my lord, reply I have received, my lord, have a look at. Date of participation. Oh, my lord, page 80, my lord. First point, my lord. This has been communicated long after almost 1 year.
Very good.
This communicated already, it is an invalid communication as per the settled law. Second, my lord, it shall be accepted or rejected by the appointing authority, my lord. It is a mandatory requirement in the both the rules. But it was issued by the Director of Medical Education, my lord. So this rejection petition itself is void, my lord. Third, my lord, mandatory requirement is the public interest, my lord. All judgments, all statutory books, public interest. But no mention here, my lord, it is in the public interest. And what is the reason for rejection? Nothing is mentioned in this application. Have a look at the page 80, my lord. Because, my lord, appointment letter I have also enclosed here it. He was appointed by the governor. And at least this rejection was neither issued by the governor nor in the name of the governor, but arbitrarily and maliciously, my lord, it is issued by the Deputy Director of Medical Education. My lord, short fact, my lord, this unfortunate petitioner, my lord, continuously victim of the health department, my lord. And there are different corruption now every day is coming before the newspaper and TV. Even, my lord, present health minister discloses there is a major corruption in the Shastra Bhavan, my lord. And, my lord, my client did not oblige at that time. That's why this is the fate. Now, my lord, my client salary, he was drawing salary even after 20 years, same as the
There was issues for consideration here. Those issues are not rising for consideration.
I'm not, what is the background?
That's all.
And please, Honorable High Court
Yes, very well.
interfered and
Those issues don't,
ordered the issue.
those issues are not arising, sir. Yes, sorry. You can't argue
Okay.
everything.
So my first point, my lord, this is after,
We have taken note of all your 3 points. Under under the CRB, automatic after 3 months, incompetent authority.
Lord.
Victimized. All 4 issues. That's all.
not public, not by appointing officers, not by the appointing officers.
Correct.
So already by operation of the law, my lord, he already has been retired, but his pension is still pending, my lord. When pension is
You have
the
not given the date of your application.
Date of application for
Yes, I know. 24 to 2020.
pension.
application for retirement টা কবে করেছিল?
Date of application, my lord,
24 to 2020.
24 to.
Which page? Where is the application?
Page 65, my lord. My lord, I am running with the 80 years, my lord. That's why I am taking some time, my lord. Non-receipt of any communication within the specified period from the accepting authority shall be presumed that the notice of voluntary return is accepted and retirement shall be effective. This application would have specifically, it was mentioned, my lord.
Yes. Yes. Under which provision? He is saying 59 of the DCRB. What is your submission regarding Rule
My
59?
lord, my lord, should I give you?
If he has not served anything.
It's gonna help, education and health. কথাটা বললেন না। এখানে হচ্ছে এই যে এখানে আছে মেডিকেল হেলথ সার্ভিস আছে, মেডিকেল এডুকেশন সার্ভিস নেই।
Retiring pension lordship is only speaking of the health service. But
What is 59?
59 is retiring pension in the case
It is
of
the retiring
members of certain services. Members of the following services or holders of the following posts are entitled.
Are entitled. It says who are entitled.
Entitled.
Yes.
On their resignation being.
Being accepted. Once it is accepted.
Once it is accepted.
Yes.
Retiring pension after completing qualifying service of not less than 25.
Very good.
So it was opened by lord.
Heard the learned
My lord, it was a very clear case, my lord. Three judges bench, my lord. It is
Hold on.
voluntary retirement confined exclusively,
Hold on.
my lord.
Item number 6.
Item number 6, Lordship, this is an appeal by the state Lordship records may be sent down because I have to get the particulars and
As read list after
Four weeks.
in the meantime, the learned DGP may ensure that a
same order for 7 and 8 also.
6, 7, 8.
6, 7, 8. Action. 4 weeks. ঠিক আছে।
Madam, 31st of
ঠিক আছে। দেখে না রেকর্ডটা দেখে
ঠিক আছে কয়টা আইটেম 7
7, 8 action. 7, 8 action. 9. 6, 7, 8 ও তাই 8 ও তাই
কেন
8 ও একই
আইটেম 9
none appears for the writ.
item number 10
Item number 10, my lord, I am appealing for the petitioner.
Lordship, these are matters which are appearing for the first time probably. Lordship, could they
Yes,
serve a copy on the
Lord, I shall,
the
but
learned
I shall,
That's
lord, but
fine.
on the last occasion when the matter was taken up, my lord was of the view whether at all the petitioner is entitled to the interest delayed payment of gratuity and pension. Now, my lord, with payment of gratuity and pension, because my lord, prior to the superannuation of the petitioner was put into the case of a criminal proceeding and a disciplinary proceeding was initiated. Thereafter, by the department, thereafter in the year 2022, petitioner was discharged with acquittal, my lord. Now, thereafter, the pension, the commuted pension, and the gratuity was paid, but the interest for the 10 years was not paid.
Date of charge memo.
Charge memo. So that is 4th of August 2022. Sorry, 2012.
4, 8.
4/8/2012.
Charge memo in the disciplinary proceeding.
No, my lord, not in the disciplinary proceeding, my lord, but it is in the with regard to the criminal proceeding, criminal case.
So this is the charge sheet filed in the criminal case.
Yes.
So when you were placed under suspension
No, I was not suspended, my lord. In 30th of July 2012, I was demoted from UDC to LDC, and I superannuated, my lord, on 31st of August 2012. So for 1 month, I was demoted to LDC, but prior to that, I was a
the
UDC.
date of that punishment?
Punishment, my lord, 30th of July 2012. No, acquittal is not a punishment. I was acquitted on my lord 31st of just a minute, my lord.
December 22.
No, January, I was acquitted on 24th of February 2022. 24th of February 2022. I was acquitted.
So this demotion on 30th July 12 has no nexus with the criminal trial.
Yes, my lord, because they found me that there were some documents in my custody that those were gone missing. That's why they have demoted me for that 1 month period. My lord, after that, I was superannuated.
You were superannuated on?
On 31st of August 2012. Now, thereafter, once I was acquitted, my gratuity, my pension, and my
Charge sheet is 4/8/2012 in the
Yes.
criminal trial.
yes,
And the acquittal is in the trial or in appeal or
in the trial itself.
trial itself. So you must have got this ad interim allowance?
No, nothing.
Nothing.
Only after I was acquitted, they paid me in the year of 2023, my lord, they paid the pension, the commuted pension, and the gratuity. But interest they did not pay.
When they paid you?
Kindly grants me a moment, my lord. My lord, they paid me on two occasions. First on 19th of December 2022, and thereafter on 5th of January 2023. The arrear part. In two installments, they have paid me. No, আপনি আছেন শুধু। মানে শুধু স্টেট না এফিডেভিট ইন অপোজিশন এর ডিরেকশন আছে হ্যাঁ
আজকে কি
হ্যাঁ, হ্যাঁ,
কবে?
2022
22
লাস্ট অকেশনে জিজ্ঞেস করছিল আদৌ এটা মেইনটেনেবল কিনা চাই স্যাটিসফাই করে তারপরে আমি
দাঁড়ান দেখি। এটা মেনটেনেবিলিটিটা উনি প্রশ্ন করেছেন। কোর্ট প্রশ্ন করেছিল মেনটেনেবিলিটি।
সব দিকে ঢুকে লাভ নেই আচ্ছা 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 ইন্টারেস্ট এইটা হ্যাঁ
So prior to the conclusion of the trial, you did not move for grant of any pensionary benefit?
Milord, since Milord, prior to my superannuation, I was acquitted. I was charged. Milord, my seniors in my office, Milord, they said that I will not get anything until and unless I am acquitted. So, Milord, that's why the petitioner did not move anything, Milord.
So he is not guilty of any being sitting idle for
No,
more than a
Milord,
decade.
he is not guilty for anything, Milord.
Nothing, yes. Very.
Milord, he is not.
Why you were in a rush to come immediately after the acquittal? You should have waited for another 5
Milord,
years.
once the acquittal is done, Milord, I have come. Milord.
Should have waited another 5 years. Come for interest for 15 years instead of 10.
No, Milord, the moment I was acquitted, I wrote a letter to ask you. You are supposed to give an answer in the investigation be considered. My senior said so. In the interaction, Milord, I did not.
So say yes or no.
No, I did not, Milord.
My senior said, what a reason, as if it is a mitigating circumstance.
I did
Coming
not.
to your
This
aid.
is the fact.
You have allowed this situation to pass for 10 years. Since 2012 to 22, you didn't need the pension, obviously. Not taken any steps. Only after the acquittal you have come to the court.
Milord,
And you want interest.
Milord, in the interagnum period, Milord, I did not appeal, Milord.
Then you tell us
Milord, the law is
when you have chosen not to agitate or raise your.
the act itself says that I am entitled to the interest if there is a delayed payment on the part of the employer. There is no fault on my part, Milord. They have delayed in paying my gratuity as well as my pension.
Therefore, that is why we are asking, why did you rush after 22? You should have waited
Milord, this
another
is my
5,
right.
10 years.
Milord,
It was earning interest for you.
Milord,
Wonderful way of
Milord,
making
this is
it.
my right.
Then you have to assert a right.
Milord,
You are here asserting a right.
Milord, my right cannot be infringed.
Right, that is all. Yes. Why didn't pay as per the.
They are yet to be served,
It
Milord.
has not been served, Lordship, I'm not aware.
The tribunal has decided or it was still pending?
No, it has been decided. Milord, the order is annexed, Milord, at Milord, page 55. No, extra copy nahi Milord. हम की दवा की The order starts at page 55, Milord. The ordering portion is at page 56. Madam,
File an affidavit, we'll see.
there is a direction of affidavit, Milord. Let me serve my learned senior friend, Milord, in the course of the
Affidavit in opposition be filed within 3 weeks.
admit, my lord.
No, you have given us, why we will give you back? Call the judge next.
Milord, I have served the copy, Milord. And let it be recorded, Milord, I have served the copy.
Item number 11. 31st August.
In item number 11, Your Lordship.
দিয়েছিলাম ভাই
In item number 11, Your Lordship, I am for the petition, Your Lordship. Yes, Your Lordship. On the last occasions, the report was submitted by the Your Lordship, the state, where Your Lordship, on the report, it appears, Your Lordship, the vacancy is there. If Your Lordship can recall the matter, Your Lordship, since the matter pertains, Your Lordship, the petitioner is the.
Petitioner cannot be eligible to get the appointment, get the recommendation because
You have filed an exception to the report.
Since Your Lordship, the vacancy that is there, it has been indicated that the vacancy is there.
Why you have not filed, we are not asking you. We are asking you.
No,
whether
Your
you file, you are not filed or you don't want to file. Understand?
No, Lordship, I don't. এটার এক্সেপশন নিয়ে নিয়েছে তো তুমি তো
মানে দেওয়া আছে
এক্সেপশন তো ওটা আগেরটা আছে
Text এখানে আছে Lordship, I take your Lordship's leave.
since Lordship the matter Lordship the petitioner is an eligible person Your Lordship cross stages of recruitment process conducted by the PSC. For the post of Your Lordship, the fire services supervisor of the fire department, Your Lordship. When he was selected, thereafter second list, merit list was published that he's on it was the remark that he is not eligible due to the Lordship, the OBC that was not submitted on the Lordship. Since Ramkumar Giriraj, that judgment was cited, Your Lordship recorded the order on the last occasions by an order dated 11th.
Well, possibly the exception is not required to be filed, my lord.
No, we asked him, if you want to be sure that you are proceeding. When did you file the report?
3rd July, my lord. এই তো রিপোর্টটা কপি নেই হবে না? ও, এটা কে দিয়েছে? এই রিপোর্টটা কে দিয়েছে? স্টেটের স্টেটের entire thing. 14, so 17, 26. Hour of 16. Okay. There is no order sheet in this. My lord, one thing, my lord, junior is insisting to submit, my lord. What had happened, my lord? He was declared as successful,
Yes.
but after the publication of the merit list, he was excluded, my lord, and he did not have any scope to raise any objection.
You are submitting anything in addition to 17.6 order. Therefore, we are saying
That's-
that bonds.
That's
29/6/2026. 29/6/2026 order.
Yes.
Lordship. There is a lordship, there is a, that is 29/6/2026 order. Lordship
Yes,
mentioned that
recorded
why his name was not recommended.
Great.
There is no issue of vacancy. You are only saying he has availed the opportunity. He did not object when objection was.
Not recommended.
My lord, I am covered by the coordinate bench judgment, my lord, passed by Justice Harish Tandon and Justice Proceedings.
That is,
Yes.
it's one judgment is in the report.
I have
Lordship, that
handed over the
judgment
judgment.
is in the report.
And it is also annexed in the report filed by the state government.
Item 12. My lord, I'm for the state. On the last occasion, there was a direction to file affidavit in opposition to a supplementary affidavit. My lord, we have received the case file on Friday. My lord, we request some more time. My lord was pleased enough to grant us time for 2 weeks from 14th of July. Another 2 weeks may kindly be granted.
Granted earlier.
Item 13. My lord, item 13, I am for the petitioner, my lord. My lord, petitioner do not want to proceed with the matter.
Item number 14,
My lord, I have got a petition.
Filing their opposition.
opposition.
My lord, then my lord, my client has come today. My lord, it is being affirmed, the reply is being affirmed. My lord, let the matter be taken up next week. I am serving them reply.
Affidavit in opposition. Affidavit in opposition.
Dosh.
Okay.
Item number 15, Lordship, item number 15, on behalf of the Lordship, item number 15, on behalf of the appellant, I am praying for a week's accommodation.
My lord, in this matter, I am appearing for the first time for the state, my lord. What I have been instructed, my lord, in the earlier order, liberty was given to file a supplementary affidavit. If your lordship allows, my lord, may I file the supplementary affidavit, my lord, and your lordship may fix this matter for hearing on any day, my lord.
By which order? 9/4/26.
My lord, I'm sorry, my lord, but I do not have the order. I have just 9/4. My lord, 9/4. Thank you. 9th April. Which is said. Very well.
You're filing
He has been allowed to appear. Grateful.
Data. Item number 16,
My lord, I appear for the state, my lord.
I appeal, my lord, for the petitioner. From the last date, my lord, Mr. Kushal Charismal was arguing, my lord, he was on the verge of conclusion, my lord, he needs some. Mr. Tadisi, my lord, is now on his legs in court number 37, my lord. It's a hearing.
Not today.
I'm praying for a not today. Not okay.
Not today. Later when
item 17,
17, my lord, I am appearing on behalf of the applicant. My lord, earlier occasion, your lordship, my lord, directs to us to file a supplementary application. That was, my lord, served, my lord, my learned friend long ago, my lord. But, my lord,
in the court, my lord. Today, my lord, I have submitted, my lord. This is the
My lord, these matters are filed after September, my lord.
Before the tribunal.
My
No.
lord, before the time.
tribunal, my lord, long ago, my lord, 25. My lord, before September.
Before September.
Yes, yes, my lord.
Where is the copy of OA? Let's see the date of verification.
There is no date
Yes,
of
yes.
verification.
Yes,
I
yes,
found
my lord.
my copy.
Yes, my lord.
Makes sense.
Can you give us the detail?
My lord, order is there, my lord. Yes, yes.
No, order does not indicate the date of filing. We are asking you.
My lord, 26, my lord, page 39, my lord, page 26, 325 in OA application.
Page
39 of the WPST, my lord. I annex the OA copy, my lord. That is the verification, my lord.
Yes, it's of March 25.
Yes, ma'am.
My lord.
Before that, my lord. So, my lord, may I proceed? Ma'am?
My lord, we'll file one
Serving-
position, my
When
lord.
you're serving a supplementary, how you can proceed?
My lord, long ago, my lord, my learned friend already served, my lord, in the month of March.
My lord, I was not there.
My lord, one day matter, my lord, taken up, my lord, before your lordship, my lord. On that day, my lord, I am.
What is the issue? Tell us.
My lord, issue is, my lord, one matter, my lord, I filed before the honorable, my lord, tribunal, my lord, for enhancement of the my remuneration according to the government notifications.
September 16/9. What is the date of memo?
My lord, memo, my lord, that was memo 9008, my lord.
Huh?
9008, my lord.
9008 is after the 16/9. It is the
Before
that there is 1177 or something like.
there are so many memos, my
No,
lord.
not thereafter. Which is the basic one is
Memo
11.
is, my lord, the 16/9/2011.
Yes, 16/9.
Yes, my lord.
That is the basic one.
Yes, my lord.
So you, according to 16/9, you are qualified.
Yes, my lord.
Were you given the benefit of 16/9?
No, my lord. That's why, my lord, I till that, my lord, I am working there, my lord.
So if you are not given benefit of 16/9, how you can get the benefit of 9008?
That's why, my lord, I filed an application before the tribunal to enhancing the my remuneration.
Since when you are working?
My lord, I am working since, my lord, 2010. So, my lord, till that, my lord, my lord, remuneration up to, my lord, December 21,000. Thereafter, my lord, immediately.
Which date you are working since which date? Where is the date mentioned? Which date?
My lord, I am working.
Yes.
My lord, the pay slip, my lord, I have showing, my lord.
Give us the date, madam. You said 2010. Which month? Which day?
I am joined.
Yes.
Joined, my lord, 29/7/2010.
29/7/2010.
Yes, my lord. My lord, according to the selection process, my lord, that's why, my lord, your lordship asking the, my lord, earlier occasion, you supporting the documents, how you selected in that post, my lord, that's why, my lord, I filed my supplementary application. I am annexing that document. So, my lord, after, my lord, filing that application, my lord, before the tribunal, my lord, my lord, whimsically, my lord,
So 29/7/2010, you started working.
Now, my.
So 9008 benefit under 9008, can it be granted without any benefit being granted under 1077?
1077
16/9/2011 memorandum is 1007 perhaps, if I remember correctly.
1007
Something like this, 1007 or 1077.
But my lord,
16/9/11 memorandum is what number? Modification memorandum number?
ওই মেমোটা তো তোমার এখানে নেই
I have annexed in my supplementary application.
সাপ্লিমেন্টারি দেখো
The number
My lord,
1077 or 1007?
my lord, 9008, my lord.
That is the later one. We are asking you 16/9/2011 memorandum.
69. My lord. That was also, my lord, I have annexed. 63.
দিয়েছো এটা তো
My lord, that was, my lord, page 63 of the WPST. No, my lord. Sorry, my lord, that was, my lord, 25th February 2016.
তুমি তার আগে
There is a 16/9/11.
9/11 করোনি দিদি দেখে
16/9/11 is perhaps 1008 then. Maybe you are correct.
Yes, my lord, 16/9.
10008.
16/9/2011, my lord.
9008.
Yes, my lord, that was annexed.
Later one is 1007.
Yes, my lord. Thereafter, my lord, another memo, latest memo, that was also I have annexed. My lord, 63 onwards, my lord.
So therefore, how you are eligible under 16/9/2011? That is the only issue.
My lord, before, my lord, the
Both of you are arguing.
My lord.
Both of you are arguing.
yes, my lord.
later argument she has started
Right, who has to argue? Then you start.
No, my lord, my lord, when I made a representation before the authority concerned, my lord, that is, my lord, page 71 and 72.
So tell us how you are covered by 16/9/2011. Just tell us.
Because, my lord, I have, my lord, my remuneration at this juncture, my lord, 20.
February.
No, my lord, at this juncture, my lord, my remuneration, my lord, 21,000. My lord, so.
How you are covered by 16/9/2011?
Yes, yes, my lord.
judgment দেখি clause 2
Up to 16/9/2011 memorandum.
Yes, my lord.
Where is it? Which page?
My lord, supplementary application, my lord, page 19.
page 19 একটাই তো আছে
একটাই দেন না, আমি দেখি একটু।
clause 10 যেটা আছে
Now read a small I,
My lord.
clause I. How you come under clause I?
A casual deliberated contractual worker who have rendered 10 years of service continuously with at least 240 days attendance each of the year may remain engaged in the same status and capacity till they are attaining the age of 60 years.
এইবার আমাদের এটা বার করতে হবে
And in the paragraph just before this cutoff date is mentioned 1/8/2011.
Yes, my lord. Before that, my lord, I joined, my lord. My lord, 29/7/2010.
29/7/2010 you joined.
Yes, my
So there is no question of completing 10 years on 1/8/2011. It is less than 1 year or slightly more than 1 year, 1 month more than 1 year.
But my lord, they have, my lord, recommended my name, my lord, on, my lord, 2019. On the basis of that, my lord, we file an application.
Your claim has been rejected by the authorities.
No, my lord, nothing. My lord, that was pending before the honorable tribunal.
Where is the recommendation?
My lord,
Page
recommended
74.
page 74, my lord.
serial number 1 page 74 serial number 1
The serial number 1, my lord, Rupesh Kumar Das.
এবারে বলো
My lord, here, my lord, they have mentioned the notification, my lord, 3998.
এবারে এইখানেই বলো যে এইখানে যে সিরিয়াল নাম্বার 5 and 10 এদের কেউ নিয়েছে তাদেরটা দেখতে পাবে পেজ
3998. Where is 3998?
My lord, 3998, my lord, I have annexed.
এটা দিয়েছে
Yes, my lord, I have annexed, my lord, 398, my lord, page 67. Seven, my lord.
এইটা গেছে ঠিকই, ওরা রেফার যেটা করেছে কিন্তু অ্যাকচুয়ালি আমি কাভার এই 70 9008 FP এটা ধরে নিচ্ছি। তখন বলতে হবে না, যদি কিছু বলে তখন এবারে এটা দেখাও পেজ 74 একবার লর্ডশিপস কে বলো যে 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 বলো না
আপনি আবার ক্লোজ করবে তাহলে।
So prior to joining on 29/7/2010, you were working in which company, corporation or organization?
Sir, I have working at,
তোমার তার আগে তো কোথায় কাজ করেছিল?
huh?
2010 এর আগে কোথায় কাজ করেছিল?
No, my lord, before 2010, I am never working, my lord,
What is the date of your joining, 29/7/2010 or 26/7/2008?
29/7/2010. My lord, I have annexed, my lord, page 40, my lord, my joining letter, my lord. Forty onwards, my lord. 40 is the first joining letter, my lord, to the post of, my lord, assistant district coordinator
তারপরে district
through
coordinator।
selection process, my lord. And thereafter, my lord, page 43, my lord, that was, my lord, district coordinator thereafter. In the year 2028-12-2010, page 43. Thereafter, my lord, various, my lord, different, my lord, I have working, my lord, and on December, my lord, when, my lord, during the pendency of that case, my lord, they have terminated my service. That was, my lord, 26/12/2025. My lord, without giving any notice, my lord, my appointment letter itself says, my lord, prior to 7 days, my lord, you give the notice, thereafter you may terminate. But they did not follow the appointment letter, no procedure, nothing. And 26/12, my lord, they have, my lord, only, my lord, one note sheet, my lord, to serve a casual, my lord, worker to me. A termination letter, my lord, 98 page, my lord.
And where is memo number 1091?
1091, my lord, I have annexed in my
Page
my
70,
lord,
page 70,
70, my lord,
70।
70.
এই জাজমেন্ট মিলটকে দেখিয়ে দাও,
Discrimination.
ডিসক্রিমিনেশন যখন দেবো না, এই জাজমেন্ট দুটো দেখিয়ে দাও। এটা এই কোর্টেরই অর্ডার, ঠিক আছে? ক্লাস 2A10 এর যদি এক্সেপশনে যদি থাকে তবেই থামানো যাবে, আদারওয়াইজ যেটা কন্টিনিউ কোর্স সেখানে আমি পাবো। এই ডিভিশন বেঞ্চে এই লর্ডশিপেরই অর্ডার আছে, এটা দাও, এটা দিয়ে কানাই বাস এটা দাও, যেটা বেশি শোনো এটা দাও, এখানে সবকটা আমি এখানে কনসিডার করেছে, এটা করে এটা বলো যে আমি এন্টাইটেলড আছি, এটা দিয়ে দাও, এটা দিয়ে দাও।
Tribunal has decided against you.
Oh, my lord, not decided.
Oh, it is pending.
Pending, my lord, last date, my lord, now, my lord,
Yes.
12.
My lord, we need to file an opposition in this because, my lord, if your lordship sees the prayer, my lord,
See the prayer, there are
two folds, my lord.
So about 1324, if you will come to 1324, prima facie we are of the view that you are required to give some answers.
My lord,
Please see page 70.
page 70.
Yes. Of the above category of workers. Now we don't know, we are not prejudging anything. But the above category of workers referred to in 1091 in small I at page 70. What does it mean? Does that mean that all those who had completed 10 years in 2011, they will be treated differently, and those who have completed 10 years after that, they will be treated differently? Category is one and the same. 10 years continuous. Maybe you can apply that even today, that we'll see whether you have worked for 10 years continuously. But that cutoff for date, whether that will operate against them, that is the only thing we have to see. So we don't know whether we will have to see the entire thread of these memorandums and notifications to arrive at a conclusion. So you file an opposition.
My lord.
The learned advocate for. The subject matter of the OA.
Then in that event, Lordship may kindly grants us liberty to agitate that issue separately, my lord.
No,
because,
sir.
because, my lord,
Nothing
we
which
have-
was not raised in the OA will allow you to.
No, my lord, it was raised in the OA by
Show from the OA.
by an MA.
Show from which MA? MA number?
In that way,
MA number?
yes, MA is already annexed, but the order of the MA is annexed.
You have challenged the
Yes.
cessation of work.
Yes, yes.
99.
By basis of an MA made, MA number 1 of 2026.
So they will give a reply, we'll see.
But it can be,
It will cover everything, yes.
my lord, in that event, my lord. But my lord, I'm only was praying, my lord, since it was there, some kind of interim protection.
Impossible, call the next case.
Grateful, my lord.
Item
18 who sent?
18 is also, my lord, same.
March of the regard.
17 and 18.
In this matter, my lord, they have given their affidavit in opposition to us.
18, 18.
And my lord, we are filing our affidavit in reply in 18. And we have also served them copies.
My lord, one innocuous prayer, my lord, to supply these copies which has been served before the
Already
এখন দিয়েছেন
GP officer.
আমি পাইনি এখনো
You have served in the GP office.
I'll make it Xerox, my lord, with my own cost, my lord.
As spread by Land State Council list.
My lord, if the matters may be kept together, my lord, it will be easier, my lord. Similar issues.
Matter, my lord.
Then this will also go after 5 weeks. As jointly prayed, list on.
Grateful, my lord. দিচ্ছি কপি করে দেবো।
Item number 19. For item 19, my lord, matter relates to resignation. My lord, during pendency, my lord, on 27th of July, my lord, they have accepted my resignation, my lord, the letter. They have accepted my resignation, my lord, the petitioner doesn't want to proceed any further. Accepted. আপনার কাছে কপি আমি জিতবো আমি কপি দিই আমি যদি আজকে কালকে বসে সেটা
Item number 20. You have got the copy?
I am appearing for the.
You have got the copy and everything?
Yes, man.
So who are represented? University and UGC and state also. No, CBI is at present not required. Yes. So Union of India is represented.
पार्टी नहीं है
Party nahi hai.
सीबीआई पार्टी
Who is respondent number 1?
यस सर
Respondent number 1 and respondent number 10. Who is representing 1 and 10?
हायर एजुकेशन मतलब मिनिस्ट्री ऑफ एजुकेशन
Who is representing respondent 1 and 10?
One is Union of India and 10 is state.
So they are, who are, that's why we are asking.
DOS apni DOS state. Respondent number 10 state.
No, somebody will have to represent 10 also.
সার্ভ করেছেন স্টেট কে সার্ভ করেছেন
स्टेट के सर्विस করেছেন स्टेट के सर्विस করেছেন
হ্যাঁ স্টেট কে
And Union? And Union of India?
পরের মামলা
July 2026. When? 7th July 2026.
And Union of India, same date.
7th July 2026.
Union of India কি সেম
No. Union of
সেই ডেটটা বলুন মাই লর্ড
Respondent number 1.
actually answering responding Kalyani University. All the allegation made against
That
the
is-
Kalyani University.
No. That is
I-
totally, my lord, totally irrelevant. It is highly delicate, very sensitive matter.
I have-
Highly delicate, very sensitive matter, my
I have
lord.
received
Just
RTI
one receipt, highly delicate. My lord, I
I have
just
served on Union of India.
Union we received on 15th June 2026.
Where is the receiving? Show us.
I have already it's a postal track report.
affidavit service দিয়েছেন
হ্যাঁ
affidavit
দিয়েছে।
service
You say.
Yes, he is saying he has served on, sir.
State government, I have already submitted in personally. Personally, No. State government.
Oh, not the DP office.
No. That is,
So Union of India also you have served the respondents.
service করেছেন
that is page number is 19. Page number 19.
19.
Page number 19. My lord, the state of West Bengal service to the additional chief secretary, additional charge, higher education department.
And Union of India, which page? Union of India, which page?
Union of India, that is, my lord, that is received on 12th June.
Which page, sir? Which page?
That is EW, a postal tax report.
Page 3, my lord. Page 3.
Page 3.
Page is 3.
page number 3
I just have the invoice or the
EW number?
ये Dr. Vineet Joshi, IS, Higher Education Department. Secretary to the Government of India, Ministry of Education, Higher Education Department. Dr. Vineet Joshi.
This is receipt. This is receipt showing dispatch.
Yeah. This is actually, I also received, that is a receipt also actually. It is a system, is a Jadavpur University Post Office.
You are a teacher.
That
You are
is
a teacher. You were a teacher.
No, but no, not an
You are academician.
academician.
You say yeah in court.
No, I just.
You say yeah in court.
But
At least say yes. You need not say my lord. We don't want you to say my lord. You say yes. Don't say yeah in court. You're saying yeah, as if you're casually talking something.
No, my lord, actually.
You're an academician. You are expected to use proper terminology in a court proceeding. Say yes. Don't say yeah. All right. Yes. So this is a dispatch. This is showing dispatch.
Yeah.
And for yes.
No, yes, madam.
And when it was served?
Sir, that is a 12 June 2026.
So
already it's received.
From which page you are showing? From which?
And it's
service on which date? On which page?
In which page? 3 page. Page number 3. Continue up to serial number 1 to 8.
Page 18, there is no receiving. Where is the receiving at page 18?
Page number 3.
Union of India immediately may not be required. You get information who is appearing for the state. So you get it from your respondent. He has already served. Why should he serve twice? He is in person, will not directly to serve. You have served a copy of the affidavit of service.
Yeah, and I already measure all
affidavit of service copy. Give it.
Xerox copy. Actually, at page I have my lord only one copy. I have
this affidavit of service.
No, I have a copy also. Only one. It is myself.
Give it, please.
Xerox.
Take a copy and you get instructions from the state. Yes, you are the main contesting.
Lord, my respectful submission is this, my lord. This is total personal interest litigation. Because, my lord, he was the head of the department of that, he was the head of that department, my lord. And, my lord, he was terminated. He filed one writ petition in this court, my lord. My lord, writ petition was dismissed. I have document, my lord. Thereafter, he filed appeal before this honorable division bench, which was also dismissed. Thereafter, my lord, he filed some defamation suit, such and such, which are pending before the court. Thereafter, now he has brought a new story that, my lord, without the affiliation of Union of India or UGC, we are running that course, my lord.
My lord, it is totally, my lord, it is totally irrelevant. That's all nonsense. It is
My lord, if your lordship kindly comes to page, my lord.
No, not that way. If you have got some instruction, you place it on record.
My lord, I can do that, but no instruction is his, my lord, annexure shows that, my lord, up to January 2026, we are holding affiliation. And after 2026, we are not admitting any student, my lord.
Anyway, no, it is absolutely false. It is absolutely false. Students already admission every day. And my lord, I also explained that
will explain after they have submitted their response. Then we will hear.
okay.
The learned advocate for.
The number. Right, Amkunda. Kumar Mighty. Your name, Kumar Mighty.
24th August. I think
He had seen that participant.
21, we have served the respondent, Lordship. The track report is not there, Lordship, for weeks.
You have to file a service affidavit or service.
Yes, Lordship. We have served on the other.
Or file.
I 17th August. Item 22. Item 23.
I am for the respondents, Durgapur Project Limited. I am the employer.
I was told to pray for my lord not today on behalf of the learned advocate. He's on his legs, Mr. Badi, my lord.
Item 24.
Yes. Not a respondent. I'm pretty sure. That matter, your lordship, your lordship has been pleased to hear me regarding this constable, my lord, who was scuffled with.
Oh.
Yes, that matter, my lord. I have completed my argument. I have
And
Under influence of liquor, under influence of alcohol.
extremely great.
That is your case.
Yes. And it is corroborated by medical evidence also.
Outside the unit, outside the secure area.
Outside.
Duly.
In the working place.
Yes.
But according to the CISF Act, as your lordship knows,
On duty all the time. That is your argument.
and there is also contradiction which I placed on the last one from his statements.
And documented exit from the secure area.
Yes.
Yes. Yes.
Our allegation is not with the related performance of duties.
Is not
Related with the performance of duties of the person. Kindly see section 8 of the Act, my lord. Section 8 of CISF Act.
And what happened to him in SSFC? Dismissed.
Yes. No.
Initially, my lord, the
Compulsory retirement with all benefits.
Yes.
not all benefits, my lord.
Not all benefits.
No. This punishment retirement, compulsory retirement, lesser
Compulsory
benefits.
return.
Lesser benefits.
So there is a lesser pension. Yes, you want us to see which provision?
Section 8 of the Act, my lord. May I please?
My lord, my instruction is compulsory retirement subject to correction from your lordship with all benefits.
All benefits.
Yes.
Compulsory retirement does not give, never gives full benefit.
No, what
There
is
is a
the
punishment.
Just read the punishment. Where is the punishment?
Punishment order. Yes.
Sir, you will-
Volume or request. Just a minute. কোন পাতা আছে বলতে পারবে? ভাই ভাই খুলতে খুলতে মামলা হয়ে যাবে। এখানে Just a minute, your lordship, kindly gives me
Yes.
1 minute's time.
Yes, find it.
Your lordship kindly comes to page 271 of the volume 2 of the stay application. And the relevant part
Volume 2. Yes, page 267.
Yes, 276, my lord, paragraph 9. I have carefully examined the appeal petition. This is the order of the appellate authority. I have carefully examined the appeal petition submitted by the appellant and other documents available in case files. I find the charges leveled against the appellant have been proved on the basis of evidence adduced before the inquiry officer during the course of departmental inquiry. The appellant has been afforded all reasonable opportunities to defend his case effectively. There has been not any procedural irregularity in conducting the departmental inquiry by the inquiry officer. Principles of natural justice have been duly observed in letter and spirit. The charges of gross misconduct, indiscipline, disobedience observed in letter and spirit. Now, the charges of gross misconduct, indiscipline, disobedience of lawful order and develop incorrigible habit unbecoming. That, your lordship, I am pausing here for a moment. I have shown on the last occasion.
No, where is the punishment? We just want to see the punishment. We are
Yes,
not all that we have seen.
Punishment কথাটা কত?
Then because we want to resolve this issue, whether it is with all benefits or without all benefits. That is the only thing we want to see.
My lord, come to page 223.
Yes.
paragraph 6.
With all admissible pensionary benefits.
Admissible in terms of punishment compulsory.
Rule 52.
My lord.
No, but it says all admissible pensionary benefits.
Yes. When
All benefits,
when
it
given
means all benefits.
when punishment compulsory punishment, whatever available as part of that is.
So admissible as per the punishment that you are saying, which is less than the normal.
No.
So from where we can gather this fact?
My lord,
Yes. We have understood what you are saying. Let him clarify. We want to be clear on this. You are saying the order is explicit in its intent. You said that this intention is to be read in terms of the provision. The provision does not contemplate grant of all benefits. So whatever is admissible, only that is being paid. So which provision contemplates that?
That today I am not ready.
Then how we can accept the submission? Then how we can accept this submission? Unless it is not supported by a provision. Because the order, plain reading of the order suggests with all admissible benefits. You said this admissible is qualified by the provision which does not contemplate full pension. So which provision?
First submission, my lord. Had it not been compulsory retired, he would have been entitled all the back wages. Second, twice.
Then he would have been service. He may have got salary, he may have got increment, he may have got promotion. That is not what we are asking you.
My lord, therefore, what would happen? His pay.
So there is a prejudice that you are trying to say, miss. Yes. Now, what is your point? See, there is
my lord. One by one. First submission, my lord. Act 8 of CI7. This proceeding is not maintainable at all.
Section 8.
Section 8 of the Act. Kindly have it.
No, CISF Act we have. Why you are giving?
May I give my book, your lordship?
Just wait. We have it. We have been looking at it in so many cases. Why duplication return? There is
Lordship,
negligence disability. Section 8A. Thank you.
What happened to your book?
What to it?
You found it.
Yeah. The other copy is there or not? I don't know. One copy found.
My learned senior friend has shown to your lordships, I think, section 8.
Yes.
Yes.
I shall place judgment on the. Well, kindly see.
So what is there in section 8 which you are relying upon?
Section 8A.
8A.
A. Section 8, my lord. 1. So, subject to the provision of Article 311 of the Constitution of India, to such rule as the center may make under this Act, any supervisor officer may dismiss, remove, or order compulsory retirement, or reduce in rank, or annulment the force, whom he thinks remiss or negligent in the discharge of duties.
He is not reading the second part with greatest respect.
No, that is.
Yes, so why it is not maintainable?
Because my lord, it is not related to the performance of duties. Neither, kindly see, neither whom thinks remiss or negligent discharge of duties, he neither remiss or negligent allegation or unfit. These are not the allegation.
Very well. So there is no case of negligence, therefore this will not apply.
No, not only negligence, my lord. Duty.
Yes, yes.
Remiss.
So it is not in discharge of his duty. That is the. Yes.
16 and 18. My lord, I am placing Supreme Court cases 1984 volume 1, Mrs. Glaxo Laboratories versus Presiding Officer Labor Court. Paragraph 16 and 18.
Which paragraph?
Paragraph 16 and 18. Paragraph 16 and 18. Other paragraph my page. Blind value accessing page 1. Page 1.
Para 16, page 1.
So no casual connection with the place, time and duty.
My lord, recently, my lord, or division may decided on the same ground, my lord. Yes, in second. Huh?
So issue of casual connection in paragraph 38 of this judgment also. Same issue.
Same issue.
Paragraph 38.
Paragraph 12, this judgment has been considered, my lord. In paragraph 12.
38. Please see paragraph 38.
My lord. Paragraph 12 and 30. My lord. বিরাম তো এটা জেরক্স দিতে পারবো এটা জেরক্স করতে my lord, in another case, my London fair appeared.
So this judgment you give him a copy because this is not reported. This one is reported. So
I have given all I will give you a copy. I'll Xerox and give me by today. Not a match. Ravi. Zeros করলাম যে দুটো জেরক্স করে দিতে হবে। আচ্ছা দুটাই কপি আছে দুটো দিয়ে দিচ্ছে আমি জেরক্স করে দেবো। This matter also, my lord, this my learned friend opposed me. দুটো কই গেল কোথায়? এই যে I have two copies, but I shall give learned friend after zero. Though he appeared.
On the same point, why you are giving?
The same point, my same point.
Why you
This
have
matter,
you have given two judgments and come to the next point. You need not
This
give
matter-
10 points for the
this
same.
matter I have to
same
face, my
judgment.
lord, because this matter, my lord,
So first submission is there is no causal connection with the time of duty or discharge of duty. Therefore, it cannot be proceeded against under section 8. Now
in
come
this case, my lord, my line of prayer, single bench also decided, division bench decided, my line of prayer went to Supreme Court. Supreme Court says immediately take him on duty, on that ground only, my lord. So, my lord, this is my lord, I shall give him also.
with this judgment which you are going to give us,
my lord,
in that case,
my lord.
so give that. Then why you are relying on this one? Take this back. Give us that judgment. Why you want to give 3-4
The
judgments on the?
Supreme Court judgment today we are not having, my lord.
You have the number.
Division bench judgment, no, my lord, only division judgment I am having. The petitioner told me before that on the Supreme Court he has now he has performability. My learned friend will be able to give because he was dealing with this.
I will give on the next day. I have to give a very short reply to his judgment.
But I'll come.
Anyway, well, all right. So
My
proceed.
next submission, my lord, this is a case of no evidence.
No
evidence.
Yes.
Allegation is, my lord, that I have quarreled or assaulted with some
Scuffle.
scuffle with somebody.
Scuffle under the influence of alcohol.
Who is that person? Where from they got? There must have got name of the person or some evidence must be there. Not single evidence. No evidence. Regarding scuffle, there is no evidence. Therefore, my lord, second, he was drunk, consumed alcohol. My lord, Forty.
He has yet to attain the age of superannuation.
My lord,
21 was the 2021 was the age of superannuation, and 2009 I believe the order of compulsory retirement was passed. So what Mr. Mohapatra was harping that had it been the case that he has retired on the normal superannuation period, you would have got much more naturally.
Kindly, I'm pressing my lord on Allahabad Court judgment, my lord. Para 10. Para 6 and 10.
Now, what is the proposition? Let Mr.
I am
so that
giving
I
a
may
copy.
also know.
I am giving a copy.
No, not a copy, sir. You have to, when you are placing a judgment with great respect, you have to set the ratio decidendi.
No evidence on the point of no evidence.
No, not evidence. On the basis of consumption of alcohol.
Oh.
That's
So consumption of alcohol is not sufficient.
not sufficient, not proved. My lord, this honorable High Court says, Allahabad Court says,
There is no medical evidence.
no blood and urine test.
No breath test, no urine test.
My lord. This one, and my lord.
Para 6 and 10 বলে দিন।
Para 6 and 10, my lord. আর এটা কই?
So this is a part of the submission, no case, no evidence. This is part of the
judgment, my lord. Same figure that there must be.
All right, we have understood. You need every point. You need not multiply judgments, giving 3-4 judgments on the same point.
My lord. That is my submission, my lord.
And regarding the scuffle also, there is no evidence.
No evidence.
Was it likely smell of corno definitely?
You say that you fell down.
My lord.
You have sustained the injuries by falling down.
Certain giddiness fell down, my lord.
Giddiness.
My lord. Giddiness fell down, and as a result, my lord, some injury.
And what is the nature of injuries sustained by you?
That is very good.
Is the injury report part of the inquiry?
Charge sheet chalana, I saw it.
Was the injury report before the inquiry officer?
My lord.
Was the injury report before the inquiry officer?
Doctor never produced. Doctor was never produced. Only report they obtained, that was.
Where is the report?
Report, I think it is exhibited.
Which exhibit?
My lord, if I'm, my lord, correct subject to correction from your lordship, on the last occasion, Mr. Mohapatro's argument was there that the civilians, so-called civilians who are in the river bank, they poured alcohol on this person, though there is no privity of contract, no resemblance, nothing. That was his argument.
A translation alleged fight.
Translation copy. My lord, we have given
page 24.
on the
My
last
lord.
occasion the translated.
Please allow him. Please allow him. Yes.
Oh,
Page 24 of
Volume
2.
Volume 1.
Volume 1 and 2.
Page 24.
24, my lord. 123, we have 24 also is there. Though.
Perhaps not.
Volume 1.
Volume 2.
No, volume 1.
Volume 1, sir. Volume 1.
What is at page 24?
The
medical report, my lord.
The doctor report that.
No, sir. Perhaps not.
Page 123 also, that is two marking are here.
124.
123, my lord.
Oh, I thought you were saying 20.
In this, my copy, my lord, there are two marking.
Yes, 124.
My lord. 23. 24 is memorandum. 123 is report, doctor's report.
Subansiri Lower HE project. It is of 19/5/2008.
Yes.
My lord.
Yes.
But doctor was never produced for examination.
Type copy ছিল দেখো এভিডেন্স এটা না আলাদা দু পাতা টাইপ কপি ছিল বলছি
I shall cut short, my lord, that summarize my lord. My lord, there is no jurisdiction for section 8 of the act, not related to the performance of duty. There is no evidence at all. They could not name the person who are doing my scuffle, allegiance of scuffle is made. And my lord, simple smell of alcohol is not proof of drinking alcohol, my lord. Doctor, no urine, no.
Take down.
Item number 1.
Appeal is dismissed.
You should kindly give some time for any appeal my client referring for.
Your Lordship, we-
Interim stay.
Contempt is pending during the pendency of the, when we had filed it. Your Lordship kindly grants 2 weeks.
Therefore, stay is
Rejected.
rejected. Will incorporate that. We'll give you 4 weeks time.
Develop.
Your Lordship.
Add 4 weeks.
ছোট সাহেবের চেম্বারে পাঠান।
Add that portion and send it. Okay.
I'm for the petition.
In our view, we find that the petitioners were not able to make out a claim for upgradation, regularization as organizing teachers of the madrasa in question. The order of the Chief Secretary, therefore, in our opinion, was rightly not interfered with by the writ court. The appeal is dismissed.
Item number 39.
We are considering it for the first time.
I think. One, it was taken up,
but not considered.
Brief facts were narrated subsequently. In fact, accommodation spread.
It's an intra-court appeal.
Inter-court appeal.
Group 6. Is not mentioned. Group civil rights subgroup BB8. So is it hearing matter? It's a hearing matter.
That's your lordship's hearing of the applications here.
Applications are there. No, because intra-court appeal, our determination says arising out of group 6. But insofar as the other groups are concerned, hearing and applications. So if it is past the admission stage, then we'll take it up. If pleadings have been exchanged, it is ready, then we'll take it up.
Pleadings ready. Exchanged.
Yes.
Now, your losses kindly take up the Malad. Can. There's an application can 12024.
Yes.
Can 120. Malad, we are against the order dated 4th February 2020. This order really passed on, my lord, contempt application and the review application, recalling application, both.
Composite order.
Composite. Taken.
We are in some doubt whether we are to take up this matter.
Because contempt.
No, because you please see the determination regarding intra-court appeal. Please assist us.
Appeals from orders relating to service.
Yes.
Under group 6.
Correct.
And matters relating to state tribunals will be taken on Monday and Tuesday.
No, at the bottom you will find intra-court. At the bottom you will find intra-court.
No. Keep watching. Form. Form.
21 onwards.
But from 2nd March 2026, appeal from order relating to service under group 6, including applicants connected thereto.
So this is not under group 6.
This is group 6.
Service.
No, it's a school service. We are asking you to assist. Please lay before us everything. It's not a service matter under group 6. So now what does it say after that?
Then your lawsuits will find it's not a tribunal matter. I'm skipping over it. Hearing of intra-court writ appeals.
Hearing, not admissions.
No, including application.
Then,
hearing and applications.
Classifications.
Yes, hearing and application.
Including applications connected there.
But admission, at the admission stage, the proper bench is bench perhaps of her ladyship Shampa Sarkar. Perhaps, please have a look. So it has not been admitted. There is no order admitting the appeal.
Dana.
Affidavits to exchange.
That is all right, but whether it will be considered a hearing matter or not, that's what we are trying to assert. Before we enter into the merits, we want to be clear. Therefore, we are asking.
Justice Sampashuka's division bench also, I do not find the appeal from order relating to municipalities, cooperatives, panchayat and group 5. Group 2 is before the Honorable Justice Mantha. But this is against the order of Justice Mantha.
That's a different thing, but we cannot assume jurisdiction unless it is placed on this ground that he cannot hear it. There is a way of doing it. Then only if it comes before us, then we can consider. Otherwise, how we can consider?
Hearing, Joseph, hearing.
Hearing, not
stage. Try to understand.
Many cases we have been releasing because the lawyers have been pointing it out. In this case, we have discovered ourselves.
But once affidavits stood exchange, it can't be treated in the motion stage. It has to be in the hearing.
We can say anything.
No.
Point is, there is a procedure for considering a matter as hearing. Now that is not left in the realm of discretion. Either it is a hearing matter or it is not a hearing.
Elections for affidavits are there. Exchange and affidavits have been exchanged.
Therefore, which provision says that under such circumstance it becomes a hearing matter? It has to be said by the department that this is a hearing matter.
Then according to your lawsuits, the applications only connected will be
hearing.
Only
after the hearing stage, maybe there may be some application which comes, substitution, whatever.
For formal admission, your losses won't take up.
No, see the determination. Please, that is what, because till 1 or 2 weeks back we were taken
up inter-court appeal
into
after admission.
After admission.
After admission, that's the interpretation.
affidavit হয়ে যায় থাকছে ঠিক।
So that's not, my lord. My lord, according to us,
You
after-
understand what you are saying, we were also of this view.
Yes.
But in one case, we had to look into it because the parties were saying it is not the, from what we were made to understand, the department certifies that this is a hearing matter, ready for hearing. There is perhaps a stamp or something ready for. So unless that is there, how we can? So what we can do is, we can just ask the department to clarify whether it is a hearing matter. Either they say it is a hearing matter, or dispute ends there. Or if they go to that bench, it may go before that. They will say they take appropriate steps. Stop. From the records, therefore the file is rolling out of this. Let's see what happens. The lawyer is putting down the file in the department. Number 40 and 41.
My lord, in item 40, my lord, and 41, learned GP is appearing is engaged in larger bench, my lord. If a short passover may be
Not
given.
yet seated. Not even, my lord. The bench is not sitting.
But he has been called, my lord. He has to wait there, my lord.
Let him start. Let him start.
My lord, I am not engaged in this matter.
This matter, my lord, since long it was. Which one is the contractual college teacher seeking regularization? My senior, Mr. Bikash Ranjan Bhattacharya, senior advocate.
My lord, he'll address this court, my lord. Only I'm seeking a tomorrow. Tomorrow, my lord. My lord.
Tomorrow at 2 p.m., my lord, 2 p.m.
It will be taken up, don't worry. At this position, it will be taken up. Tell us in the morning, whatever is the position. If it looks to you that is beyond reach, you tell us.
Yeah. Obliged, man. Grateful.
Grateful, man.
Grateful.
40, 41. না কত 30
40 and 41.
আমার আছে না আমি করব Srijit আছে
Item 42.
My lord, I'm for the petition in 40.
I'm for the respondent also.
He is coming.
Also, who has been called, who is appearing in court?
42, I'm for the petitioner, man.
Yes, it has been called.
Item 42.
CBI.
CBI.
You are here in 41?
Yes, 41.
Everybody is here? Yes. Let's take a brief at 40, 40.
41.
My lord.
Lord, 41 and 42.
40, 41, not 41.
40 and 41. Both the matters were taken up together. Mr. Bhattacharya, learned senior advocate, has concluded. Now, this is not pertaining to regularization of the polytechnic teachers. Now, they were appointed as contractual employees, continued for some time, seeking regularization. Now, the tribunal, yes.
Continued for some time. Yes.
Extended from time to time. Lord. Contractual employment extended from time to time. But I find, Lord, all the judgments regarding regularization have been cited to your lordship by Mr. Bhattacharya, save and except one. That is delivered by your lordship. In which, Lord, I had the occasion to appear along with Mr. L.K. Gupta and Joydeep Kaur.
Both of them are senior advocates, as your lordship is aware. But this judgment,
Whether you have seen the recent judgment of His Lordship Justice Datta in the Supreme Court of 13 July.
right? But that has been cited by Mr. Bhattacharya on the
13
last
July judgment.
No, it was not cited.
He has relied on Dharam Singh, he has relied on Jago.
And
We are saying
lastly, he cited my lord UP Junior High School Council Inspector Welfare.
What is the date?
Judgment date is 4th February 2020.
See, we are telling you for a very relevant thing.
Yes.
We want you to have an opportunity to examine the judgment. 13 July, perhaps if we are correct, you may check a few days this way or that way. Judgment which has dealt with Jago, whether it lays down a law or it does not lay down. So we will consider it. So we are telling you. So therefore, we want that you should go through the judgment. All right. Both of you, before you make your submission. You have got it.
13th July to page.
You have found it.
Justice Dipankar Dutta.
We will not give you any more details than this.
13th July, Dipankar Dutta.
Perhaps party's name is Najma Khatun. Najma Khatun, perhaps.
Wait for in that case. Then let us come back on the.
Just go through it.
Yes.
Make
Next
it not
week,
today. Make it
Not today. Just
Or
go through it. One judgment.
reference.
Everything is concluded. Nothing more. We will be considering that judgment. Therefore, we are letting you know.
Just make it not today.
Tomorrow at 2 p.m. Lord.
Find it and come back tomorrow.
Yes.
Not today.
Tomorrow at 2 p.m.
Tomorrow at 2 p.m.
Yes.
We have any matters tomorrow, 2 p.m.
Grateful tomorrow.
Just a minute.
Yes.
Found it.
No, not yet.
Grateful tomorrow.
Yes, time.
13th we get it.
Yes,
Just look through the second week of July.
Absolutely.
Go through it.
Get through, my lord, please.
পরেরটা কি আছে না ওই PBL
Item 42
যেটা হচ্ছে তো
এখানে
ICC
Proceeding this matter, I beg to appear for the respondent.
Yes.
এদিকে চলো এদিকে চলো কোন জজমেন্টটা দেখাবি
Lordship, I am led by Mr. Shijiv Chakraborty. Kindly, Lordship, keep the matter pass over. Short pass over, Lordship.
My lord, may I continue? Then he may join, my lord. I am referring to two judgments.
As prayed matter.
Grateful to.
Please. Proceed.
Item 5.
My lord, in this matter, my senior learned counsel is appearing on behalf of the appellant and he is out of country, my lord, and appearing for note this week.
Done. What do you want?
My lord, I note this week, my lord, I'm praying for note this week, my lord. He is out of country, sir, my lord. He may be returned on 7th August, my lord.
As paid list after 1 week.
Item 26.
None appears for either.
Item 27.
This one. Thank you, sir.
Oh, the second charge memo is subsequent. So how you can reply?
No, my lord, this is the wrong submission.
So give us the dates, just show.
Yes, yes.
First charge memo is dated.
I prepare.
First charge memo is 20th March 2024, page 36.
And the final order passed therein.
Final order passed subsequent to the second charge sheet, but revocation order has been passed prior to that.
No, what is the date of final order passed by the disciplinary authority? See, the law is that it will conclude on the day of passing of the departmental the disciplinary authority's order. Therefore, what is the date?
26th of May 2025, page 84.
And second charge memo dated?
Second charge memo issued on my lord 28th of March 2025, page 58.
Second 28th March 25.
My lord, second charge sheet.
So before the disciplinary authority's order.
Yes, my lord.
Yes. My lord, just 2-3 dates. Suspension order 20th of December 2023. Contemplating disciplinary postings, page 25.
What is the date?
20th of December 2023.
In the first case.
My lord, suspension.
Yes.
Contemplating disciplinary postings.
Yes.
On the basis of that, charge sheet 20th March 2024.
Very well. After 4 months.
My lord. Then 6th February 2025, charge sheet suspension order revoked.
6th February
2025. Suspension order revoked. Petitioner joined. Please take note of 47.
Page, sir?
47.
disposal day. Rajiv. Yes.
Last but one paragraph, we pay for appeal, page 47, which is
And under the second charge memo, he has
this is
been,
entirely in respect of separate charges, 28th of March 2025.
where is the second charge memo? Which
Page by lot 58. No face suspension, night, no, nothing.
So you are claiming arrears for which period?
For the period of suspension till revocation and
2012, 23 to 6/2/25.
And subsequently,
So where is the final order passed of page 84?
my lord, page 84, 26th May. And the revocation order has been modified subsequent thereto. That is under challenge. In fact, we prepared an appeal.
6/2/25 has been modified.
It has been modified.
6/2/25.
18 June 2025. Page 81. 18 June 2025. On our appeal. On our statutory appeal. Appeal at page 70 and modification order page 81.
So therefore, ultimately, we have to see page 84. Whether 81 is passed or not passed, 84 will become the, perhaps, even if this modification is not done, it will still abide by the final order passed in the disciplinary proceeding. Even after this modification, it will abide by the final order.
Yes.
So in any case, we have to see page 84.
In page 84, in the rule says, they have to
see. Let's see. You have seen it. We have not seen it. Let us see also see.
Page 93 is the operative portion.
Yes.
Start from page 84.
There is nothing about the suspension.
That's our case. There's nothing about the suspension. Rule says you have to conclude the suspension order. And it also says, rule also says, unless there is a termination.
Rule says if the competent authority decides otherwise.
Otherwise. And unless there is a termination or revocation of service, there is no question of withholding of money and continuation. এটা না, এটা দেওয়া আছে আমাদের তিনটা আছে নেই আপনার কটা আছে hand over the service rules. কত পেজে আছে
Give us
just a
rule 48 is the
42. Rule 48 and 48. Not 48, then 42, 48 too. Treatment of suspension, your lordship may read.
Page number 30.
Vocation order এই কথাটা লিখলো কি করে 47 যে আপিলটা লাইভ করেন দেখেছেন একটা লাইন লিখেছে 47 এর হ্যাঁ বলছে আপিল আমি পাঠাবোই না রিভোকেশন 81 আমরা বোর্ডের কাছে পাঠাবি না দিচ্ছে we have that. And if you like to kindly see the modification order of the suspension revocation, they says we decided not to send the matter to the board of directors and I decide that it should be continued. Kindly turn to page 81. This is modification of the revocation order on our appeal. Page 81.
This was impugned before the red court.
My lord.
This was impugned before
that was under challenge. Actually, this page 81 was under challenge before the red court. Kindly read my lord, page 81. This has referred to the after first paragraph, wherein you have tendered an appeal before so and so to so and so. We have carefully perused. Kindly read, take note of. We have carefully perused your appeal and is of the prima facie view that the instant appeal bears no merit in itself to be placed before the board of directors, unless there is a penalty imposed upon you in furtherance or charge sheet dated so and so. This is the charge sheet of first charge sheet, which in terms of the honorable court's order verdict so and so is adjourned and so and so. Then third paragraph, after consideration of the fact, I as competent authority in terms of regulation 2G Paschim Bangla Gramin Bank so and so modify the penultimate paragraph as contained in so and so. Further, the intervening period of his suspension shall be decided after conclusion of the disciplinary proceedings. This is the second proceedings.
So therefore, we have said now it all rests on the final order.
Yes.
Now this order is not relevant.
Absolutely not.
Now 81 is not relevant.
Not. According to them, since the subsequent proceedings has been initiated by way of charge sheet, that suspension order will be continued unless this charge sheet is concluded. But there is no reference in the charge sheet. Nothing has been done. Entire proceedings has been drawn up against me on the basis of the first charge sheet. There was no existence of any charge sheet so far the second one is concerned. Postings has been concluded so far the contemplation suspension is concerned. And the rule is very specific. You have to take a decision.
What is the punishment?
The final order I have shown to your lordship.
But it is a second first proceeding, my lord. The punishment issue.
Is secondary approach.
The disciplinary proceeding second.
Second. Page 84.
No, page 93.
Yes, 93 the operative portion. About the second class punishment.
Reduction of basic pay.
My lord.
He will not earn increment. So reduction is to the lower scale for a period of 5 years. And everything else.
Retention of PKPO, PFP, stagnation increment, if any, will not earn increments of pay during the period of such reduction and extensions.
So no decision regarding suspension period.
Nothing. But this is a mandate under the service rules. That may happen since they have withdrawn the suspension, I can understood. But subsequently, the order which has been passed, modifying the revocation order, that gives me the cause of action.
How that gives you a cause? We are unable to appreciate how that gives you. What is the difference? After 81, what is the difference?
Nothing. I'm grateful.
There is no difference.
Nothing.
It may have been issued till such time the final order was passed.
Absolutely.
Once the final order is passed,
yes.
it loses its.
Absolutely. Pardon your lordship.
Yes, sir.
My lord, kindly first come to the REIT application, my lord. In the REIT application page from 94, there are two disciplinary proceedings. First initiated, my lord. There are first, my lord, show cause was initiated in the 16th of February. First show cause initiated, my lord, in the 3rd of January 2024. Challenging that, my lord, they have filed before a writ petition before this. For the show cause notice, they are challenged before the Honorable High Court. And the Honorable High Court coordinate bench, single bench directed them to conclude the disciplinary proceeding within 4 months.
How these facts are relevant, sir?
Kindly-
Come to the relevant date. Why you are going into the day he was appointed? How that is relevant?
Sir, they are annexing both the copy of the both
Yes.
writ
No,
petition.
how it is relevant, you tell us. There is a revocation of suspension
Hello,
done by you on 6th February 2025.
another application is pending by the order of the Honorable High Court. We cannot.
We are not concerned with that. We are only concerned here with what is before us. Suspension revoked on 6th February 25.
My lord, that's why my lord is saying that come to the REIT application, my lord.
Not required.
In the REIT application, they are annexing both.
Let them annex whatever they are annexing. How that makes a difference? They are confining the relief only to this issue. So you answer this issue. Forget about what they have annexed.
Proceeding initiated against him, my lord.
That they have said. You are not saying something new.
In the one disciplinary proceeding is stayed as per their instance, my lord, in the Honorable High Court, because they are saying the charge.
We are only asking you how you withhold this period, this benefit of the areas between subsistence allowance and salary for 2/12/2023 to 6/2/25.
First disciplinary proceeding is another. The first disciplinary proceeding which initiated is up to charge sheet. Thereafter, it is not concluded yet. It is the second. আপনি স্যার প্রথম থেকে আমি আছি
বলছি সেটা তো এখানে এটা পর কোথায় চার্জশিট কোনটা রেফার করছো
Sir, they are annexing the two different proceeding in a, and they are making it creating hodgepodge. This is the document, my lord, in the.
So we are giving you the opportunity to clarify everything.
My lord, this is the document, my lord, giving, my lord.
They are creating a hodgepodge. You clarify.
My lord, they are this is the first proceeding, my lord. It is initial.
How it is relevant? We are not concerned with that.
Because the district proceeding is pending, my lord, till now.
Which proceeding? There is a charge memo of 20th March 2020.
There are two charge memos, my lord. There are two charge memos.
There are two charge memos. You have said 12 times. You need not say that again. You told us that there are two charge memos. Just saying there are two charge memos that will not improve your case.
One charge memo, my lord. One after charge memo, one proceeding is stayed by the order of this court.
Forget about that. Where is the basis to withhold for this period? That is the only issue. What's happening in those proceedings, we are not concerned.
Well, district proceeding is not concluded yet, my lord.
It is. It is concluded.
In one case, my lord.
That's all. So he is only claiming for that period. How the second charge memo can have an eclipse on his dues? That is the only thing. You tell us how it has an eclipse on his dues.
My lord, first charge sheet was initiated. First disciplinary proceeding initiated prior to the next. In the second disciplinary proceeding, it is up to conclusion. It is up to the appellate authority. But the first disciplinary proceeding, it is pending till after charge sheet it is staged.
For first line for.
Well, I'm giving my lord.
You are submitting that the proceeding instituted on the basis of charge memo dated 20th March 24 has not concluded.
There are two charge sheet, my lord. One, my lord.
Again, you are saying the same thing. There are two
charge sheet dated 23rd, 2025.
We are asking you a specific query.
I'm giving
you. It is still continuing. So the charge memo of 23/24 is still continuing.
23/24 is disposed.
That's all.
25, my lord. It is 20.
Forget about 25. We are not concerned.
2025
We are not concerned with that. That hardly matters.
Same, my lord, same.
In the charge memo where you have issued an order for suspending him, show from the second charge memo.
He is not annexing anything, my lord.
That charge memo is before us. We have just seen it. You have not bothered to go through the brief, unfortunately. Don't make baseless and headless submission.
Two different judicial proceedings are started, my lord. One is pending due to the order of this coordinated single bench, and another is reached its finality. And
no, the first reached its finality, another is pending.
The disciplinary proceeding which started first, my lord.
That is over.
That is not over. That is stayed by this court.
Again, we are asking you. The first one is on the basis of a charge memo of 20th March 2024.
But the suspension issued, it is earlier, my lord. It is suspension order issued on the 20th, 12, 2023 on the basis of the first. Well, kindly look in the papers, just not because no opposition has been.
You are not making any sense. That's the whole problem. If you just want to continue to make a submission like that, you please continue. We'll hear you.
Kindly look into the so-called.
Say as much as you want.
Well, he is not annexing those documents, my lord.
He has got everything that we have to see. If there is any shortage, he will fail. Forget about what he has done. We are asking you the charge memo of 20th March 24.
Yes.
It has culminated in a final order or not?
It is culminated final order.
Then how much is problem? You say both things.
25 is pending, my lord.
Forget about 25.
25 initiation is the first. It is initiated in 2023 by way of so cause.
No, the second charge memo is 28th March 25.
Suspension order and the so cause is initiated first, my lord. So cause is initiated on 16th of January 2024, which is pending.
16th March 24.
16th January 2024. There are two decisions. 16th January 2024.
There is another charge memo.
Another show cause, and thereafter.
Forget about show cause. There is no proceeding unless charge memo is issued. Yeah, we expect that at least this much law you know.
That is pending, and
so forget about show cause. We are not concerned with show cause.
Proceeding starts from the date of issuance of charge sheet, not the show cause.
And my lord, in the next one cases, my lord, regarding the suspension of revocation of suspension order, my lord. It again explosion of that. 6 to 25. Six 25, 48, page 40. What is it? And page 44, by the order of another bench, it is there. That's why we are not proceeding with the second one. And my lord, the revocation of suspension, it is 6 to 2025. It is annexed in page 47. This is the revocation order.
You have filed an opposition before the single judge.
No, my lord, there is no scope for filing opposition.
It was disposed of on the first day.
Yes, yes.
Order goes against us.
No, that's all right. But before we pass any order without opportunity, how
Anathan cannot say anything that any documents have been suppressed.
we cannot presume. If they are entitled to an opportunity,
All documents are annexed.
let them file an opposition. We have seen, we have understood, but
how can he improve his case by a filing affidavit? I don't
that
know.
we'll realize only once they file the opposition, whether they can improve or they cannot. Let an opposition be filed. And without date. Never in this bench, you will not come across one order in which we have not.
My lord, always fix the date.
Yes.
Always.
Service rule. But may I take back the service rules?
Please take it.
Shall hand over on the next day.
It is affidavit or service? What do you want to take back?
Service rules.
Oh, yes.
I shall hand over on the next day. দুটো আছে.
Item 28.
Can you see the previous order?
Yes, what have you done?
Lordship, so far as the benefit is concerned, Lordship, we have deposited one part with the gratuity authority, because I cannot hold the gratuity with me, even if he is not giving the document. I have to deposit with the ALC, Assistant Labour Commission. That I have done, so far as gratuity payment is concerned. And so far as the PF Provident Fund is concerned, we coal companies have a separate provident fund authority. We have deposited everything to it. Now, this on the last order, if your Lordship see, court has given them a direction that you please collect those money. It's a huge money without prejudice to the right and contention in the appeal. Lordship, so far my instruction goes, as of today, he has not applied for that.
You have discharged your.
I have discharged because under the statute I have to do this. I cannot hold the money with me. Right. Then I have to pay interest on that. So I have given that.
When you have done that?
Lordship, I have done that. So later. No. You have done it on 27th May 2026. My Lord, may I hand over this letter?
So prior to passing of our order, it was already done.
No. Lordship.
Our order is 1st July.
Prior to that, may I hand over those letters? It is to inform you that I am reading the last but one line. The amount deposited.
No, where is what is the this is about regarding gratuity and PS?
Yes, PF is also with them. PF at all. PF at all. PF at all. Yes, Lordship. My instruction goes is, may I hand over? But Lordship, I have only page. Lordship will find that. Copy. Lordship, second. Pension claim coal mines provident fund. Lordship, 15,76,000 is the gratuity which I have deposited. This is my private communication for my client, and provident fund is this, Lordship. So, Lordship, so far as his.
Where is the provident fund? You said paid.
No, Lordship, this is this. The claim has been forwarded to the Coal Mines Provident Fund organization.
Where is that?
I have just handed over my one.
Please read. Where does it say which?
At the bottom, Lordship. Yes. The last line. On 22nd July, Lordship.
22nd.
Yes.
17 July.
28th July, Lordship.
17 July
all right. 17 July he submitted us the document. So 17 July he has submitted the document for that, and 28 July immediately we forwarded, and then Lordship, this is the letter.
Oh, number 2, point number 2.
Yes, Lordship.
Is it point you are referring to point
yes,
number 2?
Yes. This I have done on 28 July, and I received.
Why we are saying it is after the court's order, not prior to. You said May.
Yes, Lordship.
So we were wondering if that was
gratuity is prior. Lordship, I have just handed over the first letter. Gratuity is prior.
Why you are not taking these amounts?
Because
some problem.
8 July, my lord, in pursuance to my lord's order, we went to the office, we deposited all the papers.
Now it is now
they are not giving.
No, 28.
Submitted all the papers. Kindly have a look.
No, after this. This is of recent.
28 July.
This is recent.
First time they are referring.
Of course. 28 July we have done it.
We are anxious that you should get the money before we proceed. You go and take it.
We kindly fix a date. Tomorrow I'll go and take it.
How they will get it? You tell us.
Lordship, one application he has to do it before.
I have done it.
Yes, what do you want him to do?
One application he has to do CMPFO authority. He has to go there. He can get it tomorrow itself, credited to his account. and one is ALC of his local jurisdiction. Durgapur.
This, whatever.
Central running, not
When you are
Durgapur.
saying CMPFO,
Yes.
you have no role in CMPFO.
That's a provident fund, like every company has a provident fund account. This is a provident fund. I forwarded to the provident fund. He will go there and he will take it. He will.
There is a procedure for how he is to take it.
They have a form fill up giving the bank detail, account, survivor's name. He will submit and that will be credited by 48 hours. And this is not my organization. This is outside my organization.
He is a retired person.
Yes, he has to go. He has retired. So he has to go submit those documents along with Aadhaar card.
Take the dues.
Kindly fix up a time, date.
How can we, these authorities are not before us? Neither this CMPFO is before us, nor the gratuity ALC is before us. How we can direct them? We give you, since they have given this to you, we don't see any impediment.
Still now, not.
Give him a copy. Please, you give him a copy. Mr. Talking to you.
I've given him already copy.
This is the gratuity one you have given.
Give him the
personal communication. How can I give it to you? My lord said so. I've given you. It's a personal communication.
Then you should not be giving us also. It's a privileged document. Why you are giving the court?
No, that's
Take it back. Take it back. Give it to him. This is a privileged document. Why you are giving the court?
No, my privilege. I have a. No. Before the judges, I can give him.
We'll not look into.
What I said. When he shouted on me and said, no, I have not received, I said, gratuity I have given. Sir, please, my lord, please.
Out. When you walk out, you will again be friends.
Might be not. What about you?
So there's no point in shouting in court.
So, Lordship, what I said is,
we are looking at the interest of this labor.
Lordship,
This
Lordship,
just facilitate so he gets the dues. We will see whatever we have.
He will give me an evening call and I know I will do it for him.
Give it to him. Give him.
So, Lordship, I will do it for him. So for this, the enter 30 lakhs or not, Lordship, he will get it. He has to only cooperate. He has to go to CMPFO office once, banking.
CMPF, we don't
want arguments. We want to know what is the difficulty. What is the difficulty? We want to know if there is any difficulty.
At 8th July, went to the office, deposited all the papers.
Please don't talk about history. We are asking you after this has been done, is there any, you perceive any difficulty? After they have come out with instructions saying that it is deposited in the Provident Fund account, you perceive any difficulty? How can you?
CMPF authority কাছে টাকাটা জমা করে দিয়েছে মানুষটা না দিলে আমি জানবো কোথা দিয়ে
If you don't want to share the document, you give him just the details on which date.
Not only that, I will also talk with the lawyer who works for
Ask them to
CMPF.
facilitate.
I will facilitate him.
I'm absolutely blind. On 8th July, I went to the office with the assistants.
You have said sufficient number. We have understood. Now, if they have done something, get the benefit, come back, then we are informed by the learned advocate for the EC. Item number 29.
On behalf of the appellant Shomodi Pishash, I am praying for an adjournment for this week. He is not well. He's down with high fever. He has requested me over 10. Shomodi Pishash.
Give your appearance, MS so-and-so, learned advocate.
Item number 38.
My lord, it's my appeal, my lord.
And for the respondent. My lord. My lord, I pray for not today, my lord. I laid by Mr. Sudhir.
All right, not today.
Item number 31.
Who's for the state?
Your Lordship, Madam
Yes, the
Chandni
state was
Alam.
not there. Is
Yes,
she?
I had handed over the judgment, copy of the judgment today, and she told me that she will be here, Your Lordship, but
Nobody's here for the state.
We heard this matter.
Yes, there is a delay of how many days?
708, Your Lordship. On we had filed the intervenor application 2025 on 14th of May. 1 year has lapsed in before the Honorable Single Bench, Your Lordship. Can one. Can one.
You have challenged which order?
23rd of April 2024. Since it was pending for more than a year, we filed this intervenor application in 2025, and after that it was never heard, Your Lordship.
You file your can on which date for intervention?
14th of May 2025, Your Lordship.
That is how many days after passing of the order?
Almost 1 year. 1 year
After passing of the order by the writ court.
Yes, Your Lordship, because no further order was passed.
And then after 14/5/25,
yes, Your
your
Lordship.
can remain pending for how long?
1 year.
Then you can approach this court.
Yes.
So 1 year prior to filing of can and 1 year after filing of can.
Yes, Your Lordship, because we had mentioned it on several occasions, almost every month on two.
So have you said so in your application?
Yes.
Condonation, let's see.
You get a copy down.
It is can number?
Can 1, Your Lordship. Can 1. I had mentioned this in paragraph 9, page 7. Due to the said stay order, the entire recruitment process has come to a standstill, causing severe prejudice and uncertainties to the candidates, including the petitioner, who have been awaiting the conclusion of the process for a considerable period of time. That the matter is pending since a considerable period of time before Honorable Justice Shogata Bhattacharya. The intervenor application was filed by the appellants on 14th of May 2025, but till date the same was never listed for consideration. The matter has been mentioned several times, but it has never been heard, which is acting as a hurdle in the adjudication of the case. The CID has been directed to submit a further comprehensive report on the next date, returnable date on 31st July 2024, but unfortunately the matter remained unattended thereafter. Xerox copy of the intervenor application is enclosed herewith as annexure A2.
Let us file an opposition to the application, then we'll consider.
We will get a deeply obvious, your lordship. It may be decided by your
But
lordship.
it is more than 700 days. And
A cause of action is continuing, your lordship. Grievances are there.
you are praying for a condonation of so many number of days. Only after they file an opposition, we can take a decision on that.
Your lordship, if she has no objection, she can,
Then we can proceed.
because these students are from.
No, we understand, but
it is.
must have seen the judgment, recent judgment of the Supreme Court.
Yes.
So therefore, 700 days we cannot just deal with lightly. We understand what you are saying, that we have been diligently pursuing if we are before the court, but then nonetheless we have to give our ruling on this issue. Without an opportunity, we can't do it. If they want, if they don't want, we can.
It will.
Give them one small opportunity, let them come back.
A small,
Yes, Lord.
limited time.
For
maybe.
filing an opposition.
The respondents are here only. And I read the copy.
Deeply obliged, your lordship.
You give that, it will be.
बिल्कुल ऐसा कई तो स्टेबिलिटी हमके इलनेस होती है स्टेबिलिटी
Yes. My lord, my respectful submission is with regard to the subsection 4 that the past treatment or hospitalization in a mental health establishment, though relevant, shall not by itself justify any present or future determination of the person mental illness. And subsection 5, the determination of a person's mental illness shall not alone imply or be taken to mean that the person
Held you to be mentally ill. Who has held you to be mentally ill? Where is the certification by anyone?
My lord, in the review medical board,
Yes, they have said you are mentally ill.
mental instability. Mental instability.
Correct. So then there is no certification. That's
lord.
only for your suitability in the recruitment process. There are 8 self-inflicted scars on your left forearm. Dispute it is not selfish.
My lord. My lord, even if even it is on the chin mark also, these are the accidental injuries. My respectful submission before my lord is what is the statute that says the guidelines which may learn it? The guidelines, my lord, the guidelines, revised uniform guidelines for the review medical examination, which my learned friend will also rely upon. Kindly see, वही page study है ना मैं खोले दीजिए. My lord will see that I have tagged before my lord. It is absolutely
Beyond what is been held by the RME. What is there in the RME? Read the RME. Read. Will not travel beyond that. Where is the DME and where is the RME? Which pages?
I have placed the page number 22 of my petition is DME. Petition page 22. আমি দেখতে জানি কপি দিয়েছি May I read, my lord? Detailed medical examination, serial 1, subject review medical examination of the candidate found unfit in DME for post of CT GD exam 2005 in Central Armed Force.
The reading from annexure A1.
My lord, annexure P5 of my writ.
No, you have given us a supplementary affidavit.
Supplementary. In supplementary affidavit, my lord.
A1, that is the form of RME.
In supplementary affidavit, I have only mentioned about the RME.
So let us see. Black mole on the left.
It says multiple scar marks on the left forearm, scar marks on the chin, and black spots over the lower. As per the opinion of the psychologist, presence of emotional disturbance, difficulty in coping up with the situational stress, multiple parallel scar marks, cut 8 to 10, supplementary. This you show to me. Presence over left forearm, self-inflicted, admitted by the candidate herself. My respectful submission, my lord, is.
So this RME is of which date? 8/12/23.
8/12/23, my lord.
And you filed the writ petition when? '26.
No, they have mentioned the date wrongly. It is 25, 8/12/25. It is not 20, it looks like 23, but it is 8/12/25.
No. Your LTI and signature at page A1, just see. 8/12/23.
A1.
At the bottom also on the left side, received result of review medical examination 8/12/23. It's 8/12/25.
It is 8/12/25, my lord. It is written. I was also under the presumption 23, but it is 25, my lord. It's 25, my lord.
Yes.
As per those guidelines, my lord will kindly appreciate that there is no whisper about any hesitation mark or cut marks, which I have placed before your lordship. As regards to the nervous instability, I have marked the another page which your lordship may give. I can take out the relevant portion which speaks about the mental instability.
How you expect them to hand over an arms to such a person? That is the only issue.
My respectful submission, my lord, is that
forget about regulation, the words stated therein and hesitation marks, scar mark. How an arms is to be handed over to such a person?
My lord, my respectful submission before my lord is that,
and whether such a person will be able to endure the rigorous requirement of an armed force, serving as a constable in an armed force. That is the only issue.
My lord.
I have to see it from that view only. We are not into mental health care and all that is hardly relevant.
They have rejected me on the grounds of the mental
You have
instability.
said so. So you have said that's your
Yes,
case.
they have said,
That is your case. We have heard it now. Don't repeat unnecessarily 10 times the same.
my lord. My lord, merely upon the presumption, my respectful, I shall try to satisfy my lordship
You
and I will
cannot.
try.
You have
I will,
signed. You have signed the
I will
RMA.
try. My lord,
Without any objection.
my lord, my,
Look into such
my lord will,
discrimination.
I will not take more than 2 minutes.
Yes.
If I can try my luck, if I can
We are
satisfy
giving you time.
my lord,
Yes.
grateful. My lord, first thing is that these candidates, they are just 10+2 pass candidates. My lord will clearly appreciate during the time of the recruitment, hundreds and thousands of candidates are in the queue, and they are just told to sign on the. This is practically absolutely impossible for them to read each and every line. They do not know the legal consequences. They were told to sign. They have signed. My second point is that if during the time of my tenure, I take it for a presumption that
Why did you go for RME? Why did you go for RME?
I was recommended because
No, you went for you can't be recommended. There is an option to go for RM. So you went for RM. Why did you go for RM?
I was temporarily declared unfit.
For on what ground? On the same ground.
On the same ground, I was declared
Now
unfit.
you please proceed. Yes. What are you?
On the same ground. My respectful submission before my lord is, my lord will kindly appreciate merely because I presume that if it is a self-inflicted cut mark, merely somebody has inflicted injury, means somebody had his cut mark during the period of his teenage or somewhere in the past, can it be taken up that in the future that person will again psychologically ill? There should be some parameter. My second point is that cases have been seen that where the some without any self-inflicted injury and such mark, they become mentally unstable and the suicidal tendency. So merely on the ground, whether my right to livelihood and my future will be taken up on stake. These are my respectful submission. What are the guidelines do they follow?
Very well. That's all.
My lord.
Heard the learned advocate for the
33, my lord, I appear for the appellant. This is my affidavit of service.
Tell you are filing?
My lord, affidavit of service, my lord. My lord, there is an application for condonation of delay, my
How
lord.
many days?
41 days, my lord. I have explained it in paragraphs 4 and 5, my lord. It's scan 1 of 2026.
What is the matter?
Well, matter, my prayer is very limited, my lord. It's regarding a compassionate employment, my lord. The writ petitioner was examined medically twice, one by our initial medical examination regarding at the time of initial medical examination, and thereafter by the apex board. Now, my lord, the findings came same. My lord, the findings were same, both of the initial medical examination and the apex medical board.
What is the finding?
Finding, my lord, he was overage. So thereafter, my lord,
So there is no contemporaneous document.
No, my lord. He filed a transfer certificate, but that was
School transfer certificate.
School transfer certificate. But my lord, what happened, my lord, in the writ petition itself, my lord, the honorable single bench judge, my lord, referred the writ petitioner for ossification test. Now, ossification test was done at the age range of 10 years, while ours was, as per our modalities, my lord, 5 years, my lord. Now, there he was found that he was less than 35 years at that point of time. So when the matter was finally taken up, and against that, I must say, my lord, when the order for ossification test was passed, my lord, I preferred an review. That review was not allowed. I preferred an appeal. Appeal was not allowed, and appellate court, the honorable appellate court, my lord, asked us, directed us, my lord, to comply with the order. So that order was complied with. Ossification test was done from the SSKM hospital, my lord. Then he was found with less than 35 years as on the date of his death of his father, my lord. Thereafter, when the matter was finally taken up,
What is the requisite age?
35 years is the maximum age. The maximum age limit is 35 years. Your lordship knows, my lord, under the national code.
There was the scope to hold that he was within 35 according to the ossification.
According to the ossification test, but according to the ossification test conducted by us, in both the tests, he was more than 35. We assessed his age as 37.5 years. So what my prayer before the honorable single judge when the matter was finally taken up was only for a third opinion to send him to AIIMS Kalyani. That was my only prayer. So that was not considered, and we were directed to provide the employment. This is the matter, my lord. We said only before the AIIMS Kalyani.
How you discredit the finding of SSKM?
My lord, two things, my lord. One, my lord, if your lordship goes through this judgment, my lord, which is assailed before your lordship today, my lord, there is a finding. I will say, my lord, it's not erroneous, my lord. Obviously, it's a wrong finding.
We are not on that. We are asking you
because, my lord,
usually you are not inclined to accept the finding of SSKM.
Yes, my lord.
Why?
Because we do not rely upon those hospitals. SSKM. We rely on whatever the AIIMS Kalyani.
So what prevented you from saying this in the early proceeding that please don't send us there, send us somewhere else?
We have sent, but it was sent to SSKM hospital.
So then there is no end after this. You may say AIIMS Delhi again.
No, it's why not? Fine, my lord, because it's final, my lord. If lordship, my lord, your lordship can record because it was my prayer, my lord.
When the court directed SSKM, did you raise any objection?
No, we said, my lord.
And you show from the order.
Well, the order, if it is not recorded, my lord, how can I say, my lord?
We know how that can be done.
But
you also know how it can be.
When I say, my lord, this order, my lord, in the final order, it is recorded that I have said kindly send.
When that assessment was done?
Yes, my lord.
When that assessment was done?
This assessment of 2024.
Do you think the assessment and accuracy will remain the same after 2 years?
Yes, my lord. It cannot change, my lord.
It cannot.
Because even, my lord,
if you will change.
My lord, if your lordship
will change. Don't say it cannot.
My lord, if that is so, my lord, our assessment was much earlier.
Yes.
Our assessment was much earlier.
Certification test was done?
Yes.
By which authority?
Yeah, my lord. It's my lord. Because it's the system which is followed, is the modalities for processing the employment under the NCAA. I have the modalities with me, my lord. This is the way we have to proceed, my lord. At the initial stage, whether we have to first.
What is the date of the first ossification?
May I, my lord? May I, my lord?
First one?
First one is my lord 24th of May 2021.
Second one?
And the second by my lord, the Apex Medical Board, my lord, it's on 19th of November 2021. And both under
And
the
what was the finding in these two boards?
35 and 40 years, between 35 and 40 years.
Where is that finding?
Yes, my lord. If your lordship takes up my can 2, my lord, your lordship will find.
And there is a delay also.
In this matter, my lord.
LPA.
Yes, can 1 is there, my lord.
How many
I said
days?
51 days, my lord.
I have no objection to that one.
Yes.
But my lord, my lord, let my learned friend make the submissions, my lord. I will submit on the other day because my lord, I am not carrying the brief, unfortunately, my lord. My lord, if your lordship kindly grant.
Let him make in your presence.
My
lord, in that event, my condonation be allowed, my lord.
Yes. The application is filed for
And to see the report. Report is made thereafter, my lord.
After filing of can?
No, we give it, my lord, and that is given, my lord, because by that time we already drafted, my lord. It's not that after the report.
Why do you should wait for the report?
But it cannot be.
Why? That's what I'm trying to understand.
I'm trying to, my lord, make my submissions. We make the application for
When you file an appeal.
Yes.
Without an application.
Yes.
The stamp reporter will scrutinize.
But we have to file the Section 5 application along with the.
No, so many cases we have seen a report that condonation application has not been filed.
Section 5, Section 5 to detail.
Which provision? Show from the appellate side. Where is that
we
required?
Have to, my lord. Let me come back, my lord. And in that event, my lord,
we have come across many cases where it says the condonation application has not been filed despite the fact that it is out of time. Don't say that they will not accept it.
Very well, madam. I have what I have to do, my lord. I will file a supplementary.
You have to. That is a technical requirement.
I will file a supplementary affidavit.
No, because see, at least we have come across 50 such cases where the application is out of the mark.
May I only make a request before your lordship, my lord? Only one request, my lord. I do not know, my lord, whether at the time of filing this Section 5 application, on many times it happens, my lord, as it has fallen from lordship, that the number of days we write, my lord, it is then, my lord, there is a pen through and whatever the report comes, we write it. I do not know, my lord, whether it is written in your lordship's brief or not.
What?
Record. In the prayer portion, the number of days. If your lordship kindly allow me to see for once.
Then how you said 42 days? Or 47 days, whatever.
It might have been, my lord. I tender my unconditional apology in that case, my lord.
Just see, have a look.
This, if it is. No, here 41 days. Back was filed.
Should not file it without a report.
Let me check it out, my lord, and let me come back, my lord.
1 week, file the supplementary, forget about it.
The same day, my lord, I think it's filed, both the cans and this.
Should not. We have filed so many appeals.
No, my lord,
But filed
I
without
think, my lord, all these three have been filed on the same day. That's why it's
There are three matters.
no, all three means two applications and the memorandum appeal.
File a supplementary, whatever.
Yes, I will. Because I have already explained the entire delay, but only the number.
Not opposing also, but let the record be.
Yes, madam. I will. Next week, madam. Grateful. 34. Wait a minute. Just a minute. 34 on here. My lord. This is my affidavit of service.
For the respondent.
This is very small matter, my lord. It's an appeal, my lord, against an interim order granted, my lord.
Arises out of a interim order.
Yes, my lord. Page 111, my lord, where the superannuation notice has been stayed after the date of superannuation. Only 2 pages order.
You have filed the opposition there.
Yes. After that, this order was passed. This is recorded, that opposition.
And allowed to. What happened on 20th?
My lord, may I? My lord, this matter, my lord, may I just say the brief fact of this matter?
20th July. It was
28th July, my lord, may I?
Please see paragraph 9 of the impute order.
28th July, my lord, there was a, on 28th July, my lord, the matter was
20th, 20. Please see
Yes.
paragraph 9.
This matter on July 20th, under the heading for hearing. Thereafter, my lord, the matter is running in the list for hearing.
Get it over.
Yes, my lord.
Get it decided.
No, my lord, it will take some time. Only why I have preferred the appeal, my lord, kindly consider. He is issuing letter after letter.
What is the date?
The date, my lord, 30th June 2026. There is a superannuation notice, my lord. May I place the superannuation notice before your lordship? It is page 82.
Yes, why you think it will not be disposed of soon?
But it will take this hearing matters only 1 day in a week. It's taken up, my lord, 2 or 3 matters. Hearing matters take time, my lord. So the way it's running in the list, my lord, the problem is not that.
The position, why?
The problem is not that. Why I have filed? Please allow me. Why?
It is appearing in the list, madam. Pleadings are completed. Madam,
What is the position at what serial number? What is
madam, may I give it to you?
I have, my lord.
This is appearing as item number 478 of the list of
monthly list.
Justice Brother Kumar Mitra under the heading hearing 3. 8.
Then it's of 2025.
2025. May I give a gist of the matter, my lord?
So you didn't file a opposition till passing of.
May I, my lord, only explain, my lord, why and why not? But that's why, my lord, I wanted to say that what is the gist of the matter.
Why we should look into it?
If not, my lord, kindly consider my prayer. Kindly consider why I have come up before your lordship today, my lord. What was the date, my lord, when the order for this exchange of affidavits was passed, my lord. It was in 8th of January 2026. 8th of January 2026.
So it took you 6 months to file an opposition.
No, my lord. Thereafter, my lord, so I was to prepare, my lord, but I feel sick, my lord, thereafter. So for 2 months I could not come to the
2
court.
months, yes, we have also adjourned. Therefore, we know it was not for 6 months.
No, not for 6 months, 2 months. But kindly, my lord, consider today one thing. Thereafter, my lord, even if I say, my lord, I have failed, even if I have failed. But one thing, my lord, kindly consider. I will make my argument only on 2 points, my lord.
No, we are not sitting in appeal.
No, my lord, why I have filed, my lord? Kindly.
Pending.
No, it's pending, my lord. Today, if I allow him,
Yes.
today, if I allow him, my lord, his superannuation debt, he has got superannuated.
If you allow him, if you don't allow him, you'll be hauled up for contempt.
Yes, that's
Forget
right.
about if you, there is the option for you not.
That's why, my lord, I'm saying I will be held
Option
for,
not to
I will be held for contempt.
You should.
Now, my lord, kindly see, my lord. If he continues, my lord, I have to pay him with all his back wages and everything, or with all his wages.
Why you have given him a notice like this?
Yes, my lord.
Why you have given him a notice for superannuation?
Because he's great of superannuation. That's why, my lord.
As per your record.
He has signed it. He had signed those records. He had signed those records. This is on record, my lord. He had signed those records. It's not that he had not signed those records. Today, my lord, we allow him, we have to pay him. Tomorrow, my lord, if he succeeds, he always have the option, he will not be optionless. Reinstatement and back wages.
Okay, we have understood what you
But if the petition fails, how will we recover our money? Because we will not be in a position to recover our money.
We understood what you
Manoj, first of all, Manoj, the matter was Manoj mentioned and Manoj appeared on the day of
Only one thing may I indicate. So far, this affidavit in opposition is concerned, only one thing your lordship will see. When did he file this scan before the honorable single bench, and when did he summon me? 6 months thereafter, 5 months thereafter.
This matter was mentioned on the date of superannuation, Manoj, and on Manoj, which my learned friend conveniently suppressed in this application, and there is no mention of the order of 30th June 2026. Kindly see this order, Manoj.
Yes, please.
Kindly see this order.
Yes.
What was their prayer before the Malord?
I didn't
learned
make any
judge,
prayer.
learned single judge, and now what they are saying here.
Didn't make any prayer.
It was listed after 2 days.
Yes.
This is after 2 days, madam.
We'll just modify it. Your right to restitution.
Yes, my lord.
Your right to restitution we will safeguard.
Very well,
What
amounts.
And then
grateful.
You will have a right to restitution of the amounts being paid in terms of the order.
my lord, and that we do, my lord. And my lord, only my lord, if a prayer, if a direction is there, my lord.
As regards the prayer for
Item 35 and 36.
Yes, the bank, your lordship.
bank.
Yes, the petitioner is called. That is.
Acha. The cap on the higher qualification.
Lordship.
But the
So there is paper book.
Lord, we have completed our submission in the last occasion, your lordship, and we have handed over one judgment, Lord, operating in this field.
Lord, please have a look at the judgment of the Honorable Supreme Court, which had given liberty to the bank to approach this court once again. But it is at page 5 of the supplementary paper book file.
Additional paper book.
It is a supplementary or additional paper book, a thin one.
35 pages.
Fine.
There is duplication.
Mark it as J1, no?
No, this is yours. That one is also yours. This also has J1.
J1.
Earlier it was 2. Later they have put J1. There are only 2 paper books. One main and one additional. There's one main and one additional. Yes.
But I represent 4 of the private respondents who had all applied, not applied, who had been appointed as peons.
So there are 4 cases.
There is one writ petitioner challenging the appointment of 5 peons. But I represent 4 of them.
And what about the 5th?
The 5th is not represented. Is not represented. But apart from the other issues,
Just to refresh, you are already out or you are still working?
but I was appointed. No, I am not working as of today because of the judgment of the Honorable Single Bench. But I had been terminated. First page of the order of the Honorable Supreme Court records that from the division bench order of this court. Please come to note the first paragraph 3 of the Supreme Court's order.
At which page?
At page 1
of the
supplementary paper.
additional. Yes.
The High Court specifically in its order dated 24th February 2020 passed in so and so inter alia observed thus. We have ascertained from Mr. so and so appearing for the bank that there is no such rule disqualifying as ineligible any person having an educational qualification higher than the prescribed qualification of having passed class 8. Learned senior counsel appearing for the appellant bank submits that inadvertently the counsel representing the bank failed to point out the factual position that there is already a rule, but the same could not be brought to the notice of the court. If that is so, the appellant bank can certainly approach the court and re-agitate the issue afresh. In view of the submission of the learned counsel that the counsel representing the bank failed to place before the court the relevant rule, as such, considering this aspect of the matter, we deem it appropriate to set aside the orders passed by the High Court in appeals, as well as in the review applications, and permit the bank for revival of the appeals for reconsideration in light of the rule relied before us. Needless to state that the appeals be heard afresh and be decided as expeditiously as possible, and we expect that the parties would not. Now, before the Honorable Supreme Court, it appears that the bank had relied upon in light of the rule relied upon before us. But what rule has been relied upon, it does not find place from the SLP. So they are trying to rely upon certain rules which were not placed before the Honorable Supreme Court. Now, what is that rule? Now, that is a question which may fall for consideration before your Lordship's court, number one. And number two, the other subsidiary point is, at the behest of a single writ petitioner who has been found to be unsuccessful in a selection process, whether this has become an academic exercise or not.
Is that issue open after the apex court's order?
But the
once it says that if there is a rule, we have to consider.
Yes. Not that your Lordships will consider this vis-a-vis the case made out in the writ petition.
No, that's a different thing. But what you're now trying to canvass, can we go behind this order passed by
the court said if there is a rule,
so that is the limited scope before us.
The issue,
yes.
But the scope, it's not the bank's appeal, it's the employee's appeal. The bank has been permitted to reopen the appeal filed by the employees on the limited scope of a rule being in existence at the time of the recruitment process having been initiated, but not all that on the anvil of the case in the writ petition.
No, because it takes notice of this fact that the rule was not placed.
Not placed. So there is a rule being placed.
So there has to be something. According to the bank, there is a rule, and according to the Honorable Supreme Court, we have to consider that.
Not to what extent? No, that's my second question. That's my second issue raised. Not the examination of the rules has to be made in the light of the writ petitioner's case. But there is a single writ petitioner who has been held to be unsuccessful by the Honorable Division Bench of this court, and whether examination will result in entailing a success of the writ petitioner qua his employment. Because if he cannot be employed by reason of not unsettling our appointment, then the writ petitioner does not warrant a relief. And if it doesn't get a relief, then not the consequence of the appointment need not be set aside.
You are raising an issue that it is academic.
No, that's my submission. But first and foremost, he has to say, all that he said in the stated in the writ petition is, he had fared well in the selection process, and therefore he is entitled to be appointed. But what was the select list? Where did his name feature? Whether my quashment of my appointment would automatically give him an employment. All these things are absent.
What order was passed by the learned single judge? We just forget.
Yes, please come
just
to the main paper book now.
Yes.
Page 1. I'm sorry, page 88.
$88.
May I please?
Just let us.
Yes. For the post of peon, there were 11 persons selected.
So his grievance appears to be that because of this capping in the higher qualification, I have not been selected, but others have got the selection, though they were having a higher.
9 were issued appointment letters. 2 posts remained vacant. By reason of my displacement, whether he would have been automatically employed in those posts.
But now, even if he abandons his claim, will the bank allow you to stay in the organization?
But he can at the most displace one of the appointees.
No, we are saying once the bank, it is brought to the notice of the bank, will they allow you to continue?
No, bank had not preferred any action against me.
Therefore, we are saying now.
Now, very good.
Now that this issue has emerged and there is a litigation which has traveled up to the apex court, wherein it emerges that you are overqualified, but you are trying to, it is your case that this will not stand in my way of working, then will the bank leave it? Even if they don't pursue, then bank will not leave it.
Then the question would come whether the bank is challenging its own action or not.
That's a different issue.
But that's an issue which the bank has not addressed through affidavit.
That's a different.
Because we were all appointed through the employment exchange.
No, but they were.
The requisition sent to the employment exchange would form the foundational basis of our appointment.
And that contained the higher qualification.
We had only registered or
say that you had not updated your higher qualification.
That's their point.
So therefore, if the bank was not knowing that you had a higher qualification, then if they at a subsequent date come to know, are they precluded from rectifying a mistake which goes at the root of your eligibility?
No, I wouldn't say that a mistake should be allowed to perpetuate, but first and foremost, a mistake has to be pleaded. The bank must admit that there is a mistake, because
today there is no, we are way ahead of all that. Admitted fact still date is you are overqualified. Admitted fact is that it was not noticed in the process because this information was not on record. Now, in this circumstance, whether despite this overqualification, you can claim to continue, or based on this overqualification, the bank can throw you out, that is the only issue.
It's not that 3 things may arise for consideration. Number 1, what is the meaning of a rule? Because the court has specifically left it open to the bank to approach if there is a rule. Number 1. Number 2, whether the bank has really acted upon such communication or instructions of the general manager. Because for all posts with such qualification, there are persons still working with who are 12th standard passed or graduates. Arising out of the same recruitment process, whether the bank has really acted upon that policy or not. That's the second question which may come for consideration.
And single judge directed to take affidavit sworn before the magistrate.
Yes, that was not necessary at all, not in my most respectful submission. And we did so. Be that as it may, we did so. Now, whether, number 1, whether it is a rule, if it is a rule, whether the bank has acted upon it. Because in the same recruitment process, all persons are appointed who are more than 8th standard passed. Graduates and undergraduates.
That can be used as a shield by you. If you are overqualified.
But I say that I am probably the bank has not acted upon this so-called rule. I say it's a so-called rule. It was not the.
How does that better your existence? That is the point. You may raise all these issues. In view of the admitted facts, how it betters your claim? Maybe some are still unnoticed or some are going unchecked, or maybe they have not acted against all. But in view of the admitted facts, you will have to confine yourself to show that, as you say, there is no rule. Then the situation would change, because the apex court says if there is a rule.
But what is not rule? Not if I may lend not this concept not from the definition of rule in the General Clauses Act.
Yes.
Then not this instruction or not that executive.
In fact, in our order, we had raised this issue. We had raised this issue.
But it only refers to a rule or regulation framed under an enactment. But thus far, whatever the bank has disclosed before this Honorable Court does not refer to any source of power being referred to a law.
We had asked them to place.
But my learned friend, not in my most respectful submission, has not been able to produce this.
On that day, perhaps this court on its own has raised this issue.
Grateful to your lordship. That's the not source of my inspiration. But rule as defined in the General Clauses Act does not mean an executive instruction. Rather, it's an instruction which must flow from a law or an enactment. And in that context, rule and regulation has been interchangeably used. But I find not from the Banking Regulation Act as well as from the Reserve Bank of India Act.
An executive instruction which supplements a rule, what will be the effect of that executive instruction?
But an executive instruction can always supplement a rule, there is no doubt about that. But not there has to be a rule. Not what is the meaning of the rule in the context of the bank's exercise?
Let's see. Let us see.
Because not if I have to say, not if the bank has to say that this is my rule, then not why did the bank not act upon it all along? I don't claim a negative equality. I submit that this is how the bank has understood its own instruction to be.
We appreciate you don't claim a negative equality. At the same time, equity will also not come to your rescue. That if it has happened, then it should. You can't. Because by now the record contains an admission that you are overqualified. So what is the consequence? Therefore, the apex court says, you see whether the rule bars. If the rule bars, you act accordingly. If not, then.
Not the rule within brackets says will not be considered. But one is.
It does not speak of a disqualification.
Does not speak of a clear disqualification. Now, today, not the qualification are before the authorities. Now, not if my case has to be tested in view of any doubt which may arise both in law and on fact, then it has to be adjudged on the basis of the attending facts as well. If there is a doubt, now, not today, faced with such action, not the bank has gone up in appeal before the Honorable Supreme Court, but they were not aggrieved, not in other way. But there was a complaint made by this unsuccessful candidate, we were transferred to a different posting. We were transferred to a different place as peons.
That hardly means anything.
No, I don't say we claim equity for that. But the bank could not have challenged its own action because they understood this notification or advertisement to be carrying a different meaning. Or not a total disqualification or ineligibility altogether. And not at the behest of a person who is unsuccessful and has failed to demonstrate before this Honorable Court.
In view of paragraph 5 of the Supreme Court judgment, is this issue open today?
Not the Honorable Supreme Court has granted liberty to the bank
to proceed on this. So can we now say that you cannot? Because you have not done it.
But the appeal is of the employees. The bank has been able to persuade the Honorable Supreme Court to resurrect the appeal.
So, and they have got an order.
In the event, there is an existence of a rule.
So ultimately it comes to that only.
Yes.
Other things, perhaps, prima facie, it appears to us that maybe there is no scope for going beyond that.
But the appeal is there. Not the appeal, in the appeal, I say that even if you can show that I am overqualified, then also the court is not required to go into this question because you will not be appointed. And when I shall be citing judgments to show that if the petitioner cannot be granted relief, then the court will not go into such question. Because it is not a PIL or a writ of quo warranto. It's a writ of mandamus.
It can be no PIL. In respect of a service matter, there can be no PIL.
No, not please recollect that judgment. Not this, that came from a central administrative tribunal's order.
Yes.
I'm not the Honorable Chief Justice presided over by His Lordship Paul, as His Lordship then was. He has held that even in service matters, PIL can be maintained.
But the apex
But the judgment, yes, it came from a central administrative tribunal's order, and in that context, the Honorable Supreme Court was persuaded to hold that there can be no PIL in service matters.
So there can be no PIL in service.
But that was on the basis of our order passed by a central administrative tribunal, which could be agitated in a 226 or 227 jurisdiction.
Because all service matters are personal.
And not in that context, the court held. But not suppose there has been a large scale, there has been a large employment scam.
No, that's a different thing. Irregularity in the process. In the process, large scale, which vitiates, which goes to the root of the fairness in
the transparency of our system.
Then of course, that also the court enlarges it. It's not filed, normally not filed as a PIL.
Normally not filed.
The courts have taken up issues, they have gone into inquiry, gone into examination, but normally not filed as a PIL.
But the sole sentence in paragraph 5 and 9 of the writ petition is that I had fared well, these persons are not eligible, therefore set aside their appointment. Now, not all these 4 appointments are set aside. Does he get appointed as a peon in the bank? And displacing all 4. Today, the bank does not run a case of misconduct against me. It's not their case in appeal before the Honorable Supreme Court.
So who is the rule-making authority?
Now, if the bank has to follow rules or not legal rules, but this rule-making power in terms of the Banking Regulation Act is only in section 52 of the Act.
We had observed this.
And that does not empower the bank to frame rules without the authority of the central government. What is this rule? Is this policy a rule, or is it a rule within the meaning of the General Clauses Act? Or even under the Banking Regulation Act? But the bank said we have a policy. If that be the policy, then the court might not have used the word rule. And not even whether this is a policy or not, they rely upon a circular of 2001 and the other of 2021. Please see the two so-called policies.
Should we proceed?
But one is at page 25 of the supplementary paper book, and the one was separately handed up.
No, should we proceed today?
But we can come back on some other day. We are nearing we are almost at the end.
We can continue if you are okay tomorrow, then we can continue. For further submissions on behalf of the plain list of dates without any
My lord,
submission.
we have got it.
Without any submission.
अच्छा, ठीक है। दे दे, आज के दिन। Not we have a list of dates prepared with the notes. Not we can hand out both.
Item 37.
Not this week. Why not?
My senior counsel is not well and he is not unable to attend the court today.
An assignment. As paid by
it 38 Malad is relates to a relevant process of 2012, my lord. Now, the tribunal came to a conclusion that because and this notification was made.
This is WPCT.
It's
Assignment.
But I appear for the respondents, my lord. Applicant respondents.
Yes.
Led by Mr. Shoma Mojumdar and Vikas Ranjan Bhattacharya.
In just I will. 2012 was the recruitment process started. 2015 the notification came in, and the currency of the panel was till 2017. Now the petitioner, the employee came in before the tribunal sometime in 2023. Now while deciding the matter, the tribunal came to a conclusion that no similar kind of order has been passed on behalf of another party who has come in 2019 after the currency of the panel. Therefore, he should also get similar benefit. That is a completely error-prone order because the party that the tribunal was speaking about, that party had come in 2016 while the currency of the panel was there. And the order that was ultimately passed by the Supreme Court was in personam with regard to his marks only. Therefore,
What is the benefit of the arguments right now?
my lord, limitation. One is limitation. Delay.
You want tomorrow? We should adjourn
We
it for
have
the
come
day.
back with a short note on this.
Lord, kindly take it up tomorrow. But after the Supreme Court passes the order, my lord, nothing remains in this matter.
The Supreme Court has passed.
It is your repetition.
My repetition.
So when do you want? Tomorrow or you want?
My lord kindly takes it sometime. I'll make a short note. It will become easier. I was briefed yesterday.
As paid by